Committee on Oversight and Government Reform will come to order, and without objection, the Chair is authorized to declare a recess at any time. A very important hearing today. As you know, the committee has jurisdiction. They have jurisdiction on federal records, they have jurisdiction on the Freedom of Information Act, they have jurisdiction on the National Archives. It's a very important part of our process. We're unique in our nation. We are open, we are transparent, and we do provide access to the American people for what they paid for. As you also know, Secretary Clinton served as the Secretary of State from early 2009 through early 2013. But here's the problem. Since 2009, there have been thousands of congressional inquiries, thousands of FOIA requests, subpoenas, media inquiries. And if any of those required Secretary Clinton's federal records, i.e. her emails, there was not a way for those requests to be fulfilled. This has created a mess and a disaster for the people on the front line who have to deal with this. And we're thankful for the 4 people that serve the United States. They serve in the State Department. We appreciate them being on this panel and having to deal with this mess that Hillary Clinton conveniently created for the State Department on her way out the door. Remember, when she left in early of 2013, it wasn't until December 5th of 2014, closing in on 2 years later, that Secretary Clinton returned 55,000 pages in hard copy format to the State Department. Roughly 6 months later, this prompted Ambassador Kennedy to ask for the electronic copies of these records. But later, the FBI swooped in because they had been given by the Inspector General. The Inspector General had highlighted that there was classified information residing in a non-classified situation with people who did not have the proper security clearance. The Inspector General found this. They did what they were supposed to do. They contacted the FBI. The FBI swoops in, and they find thousands and thousands of additional emails, many of which were classified. Most were not. Most were unclassified. But they nevertheless found federal records, not just her emails, federal records. And it's important to note that the severity of this, because the classification ranges everything from confidential to secret, top secret. You even have special access programs that require a code word access. This information was found in there. I'm sure there'll be discussion about how few they were, but there is a reason in this nation why we go to such great lengths to classify this information and make sure that the adversaries do not have access to it. To address this nightmare, the State Department had allocated roughly in 2008, $12.6 million to fulfill the FOIA requests. That has now soared to $33 million that the State Department is having to use. Unfortunately, they're using millions of dollars in lawsuits. Now keep in mind what the State Department is doing. They're using this taxpayer money to make sure that this information never gets out to the public. The public paid for this information. They have access to this information, and the federal government is suing to make sure that they don't get that. Now, fortunately, the State Department keeps losing these lawsuits. That's why we start to get and have this revealed. Congressional inquiries sometimes are feckless because state and others, and it's not just the State Department, I want to be fair, but State Department is one of the worst from my vantage point in terms of providing documentation that we ask for in congressional inquiries. It's very frustrating. And now we're starting to realize why this information is so incomplete, because even the State Department themselves didn't have Hillary Clinton's federal records during the 4 years that she served, and here we are in 2016 still trying to untangle this mess, and these people have to deal with this. You have people like the Judicial Watch and the Associated Press and others. You shouldn't have to go to court and sue in order to get access to information that should be readily available. Under the Freedom of Information Act, you're supposed to have a response within 20 days. But look at the case of the Associated Press. The Associated Press, I believe it was 2010, just asked for a simple thing. Show us Hillary Clinton's calendars. Her calendars. They wait years for a response. They get a trickling of a little bit. They finally go to court. And even with the court, State Department is saying we can't produce these. Are you kidding me? Her calendars? I'd like to see the Hillary Clinton's calendars. You're telling me you can't produce those? What is going on? So we have a duty, we have an obligation. Hillary Clinton created this mess. Hillary Clinton set up this convenient arrangement with herself. Hillary Clinton picked this timeline. I know people are going to say, oh, it's the political season. I just got this information from the FBI. We are days, legislative days, after this has happened. I flew in to go see and read the documents downstairs, and I tell you, we're going to move in a rapid pace, no matter the political calendar, and we would be derelict in our duty if we didn't do it. That's what we do in the Oversight Committee. It was founded in 1814. That's what we do. We oversee what happens in the executive branch. I do appreciate the 4 people that are here today. They have served this country and served it honorably. We appreciate their service to their country. They have been left a mess. We're trying to untangle it. All we ask that you do is share with us the truth and perspective as you see it, and that's what we're seeking. No matter what it is, we just want to get to the truth. So let's recognize the ranking member, Mr. Cummings, for his opening statement.
Thank you very much, Mr. Chairman. I want to make sure, Mr. Kennedy and witnesses, that as we address this mess and as we address this disaster, as the chairman has described it, and as we enter this hearing entitled Examining FOIA Compliance at the Department of State, that we make sure that we look at the entire problem. I want to know how far back it goes. And if we are about the integrity of this committee and truly addressing FOIA compliance, I hope we'll take a look and see what happened even before Hillary Clinton and what happened afterwards. Integrity of the committee. Integrity of what we are supposed to be about. Integrity of using the taxpayers' dollars wisely so that we might be effective and efficient in what we do. I wish I could say that I support today's hearing, but I think everyone in this room knows what is really going on here. This hearing is not about an effort to improve FOIA or federal record keeping. This is an attack on Hillary Clinton's candidacy for President of the United States of America. And just the latest in a series of attacks. The Republicans started with their discredited Benghazi investigation, accusing Secretary Clinton of all kinds of unsubstantiated conspiracies. When they turned up nothing, they just made up new accusations against her. Then, when the FBI director, Mr. Comey, sat in that very seat, in that witness chair, and debunked those allegations, the Republicans responded by attacking the FBI director and then making up more accusations against Secretary Clinton. When Mr. Comey came before us, I told him that unfortunately, while at one time he was the darling of the Republican Party, now he was being placed on trial. The chairman sent a perjury referral to the Justice Department that is ludicrous on its face. Then he sent another referral accusing Secretary Clinton of obstructing justice. These actions had their desired effect. They kept repeating the headline that Hillary Clinton is under investigation. Over the next 5 days, this committee will hold 3 hearings focused directly on Hillary Clinton. One today, one Monday, and one Tuesday. This frantic pre-election fervor is an egregious abuse of taxpayer dollars for political purposes. Today, this hearing is supposed to be focused on a report issued by the State Department Inspector General that highlighted long-standing challenges with FOIA across 5 different secretaries of state. Yet, the Republicans splashed only one picture across the advisory they sent to the press, a picture of Secretary Clinton. The IG identified FOIA challenges under Secretaries Albright, Powell, Rice, Clinton, and Kerry. But the Republican memo for today focused only on one. You guessed it, Secretary Clinton. Last night, we obtained an email in which Secretary Powell, back in 2009, provided advice to Secretary Clinton on how to skirt security rules and bypass requirements to preserve federal records. Although Secretary Clinton has made clear that she did not rely on this advice, in this email, Secretary Powell appears to admit that he did this himself. He also says that he disregarded security warnings and used his personal mobile device inside the State Department's secure space. Now, let me make it very clear. Secretary Powell is a man I admire greatly, and I have tremendous respect for Secretary Powell and his decades of service to our nation, despite the poor judgment shown in this email. However, rather than responding like Republicans have done by making a series of frivolous criminal referrals just to generate headlines to help Donald Trump, our goal as a committee should be to ensure that the historical record is complete, not limited to Secretary Clinton, but the other secretaries, Albright, Powell, Kerry, Rice. Secretary Powell used his personal email account for work, sent emails from non-governmental servers at AOL, and did not preserve these records. Yet, the Republican memo focused only on the period between 2009 and 2013, when Hillary Clinton was secretary. This memo says the department, and I quote, lost an untold number of federal records due to inappropriate record-keeping practices by Secretary Hillary Clinton and her senior staff, end of quote. Yet, Secretary Clinton produced some 55,000 pages of emails, while Secretary Powell has produced none. If we truly are concerned with preserving the entire historical record, why hasn't the committee sent a letter asking AOL to see if any of Secretary Powell's emails are recoverable? The IG also reported that Secretary Powell sent classified information from his AOL account. Yet the committee has never asked AOL to scan its systems sequester national security information, or identify employees who may have had access to that information. On this final issue, classification, I do believe our committee could play a very constructive role. And I want you to shed light on this, Mr. Kennedy, but only if we do it in a bipartisan way. This whole idea of classification. As part of our review so far, we have seen all kinds of ridiculous outcomes. We've seen agencies disagree on classification decisions. We've seen one agency say a document is classified, and another agency say a document is not classified. We've seen unclassified documents suddenly become retroactively classified. We've seen documents with classification markings that were completely wrong. And we've seen documents that are explicitly marked unclassified become classified after the fact. I do not know how anyone can decipher this broken system, and there's no independent arbiter within the executive branch to handle these kinds of issues. This is exactly the type of cross-agency issue that our committee was intended to address. And I hope we can do so together in a bipartisan way, or we're going to find ourselves in these predicaments again and again and again, where one agency says it's classified, another one says it's not. Retroactive today, wasn't before. In some kind of way, we need to address that. Mr. Kennedy, you've been around long enough, and hopefully you and the others here can shed some light as to how we as a government oversight committee, after all, we oversee state and intelligence and others, trying to figure out how we can make sure that we avoid those clashes in the future. With that, Mr. Chairman, I thank you and I yield back.
Thank the gentleman. We'll hold the record open for 5 legislative days for any members who'd like to submit a written statement. We'll now recognize our witnesses. We're pleased to welcome the Honorable Patrick F. Kennedy, Undersecretary for Management at the United States Department of State. It is proper to address him, I believe, as Ambassador, and my apologies that your nameplate doesn't say that, but it should. The Honorable Janice Jacobs is the Transparency Coordinator at the United States Department of State. And Ambassador, we thank you for being here as well. Ms. Karen Lang is the Director of the Executive Secretariat at the United States Department of State. And Mr. Clarence Finney, Jr., Deputy Director for Correspondence, Records, and Staffing Division of the Executive Secretariat at the United States Department of State. We welcome you here as well. And thank you. I believe you've been in this role since 2006, correct? We welcome you all and thank you for being here. Pursuant to committee rules, all witnesses are to be sworn before they testify. So if you will please rise and raise your right hands. Thank you. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Let the record reflect that all witnesses answered in the affirmative. It's my understanding that you're all representatives from the Department of State, that rather than giving individual statements, that Ambassador Kennedy will give one statement. We're very generous with our time here, Ambassador, so please feel free. The time is yours.
Thank you very much. Chairman Chaffetz, Ranking Member Cummings, committee members, good morning. Thank you for your invitation and your interest in FOIA. I appreciate the opportunity to discuss the State Department's ongoing efforts to improve our FOIA process. I am joined today by my colleagues, Ambassador Janice Jacobs, Director Karen Lang, and Deputy Director Clarence Finney. Ambassador Jacobs returned to the State Department in 2015 to serve as the Secretary's Transparency Coordinator. Karen Lang is the Director of the Executive Secretariat staff, and among many responsibilities, she is responsible for coordinating the Executive Secretariat's response to FOIA requests, and Clarence Finney is one of Ms. Lang's deputies, particularly responsible for FOIA matters. The State Department is committed to openness and to encouraging public interest in U.S. foreign policy. 2 important efforts underscore our commitment to openness. First, our efforts to preserve a complete record of U.S. foreign policy under the Federal Records Act. And secondly, our efforts to ensure that the American public can gain access to that record using the Freedom of Information Act. It is clear to the committee, to us, and to anyone reading the news that the State Department struggles with the volume of FOIA material. Since fiscal year 2008, our new FOIA requests have risen 300%, from 6,000 to over 24,000 requests per year. We face a FOIA backlog approximately of 30,000 requests, 17 direct requests to the State Department, and about 13,000 referrals from other agencies to the State Department that need our response or contribution as well. I want to make clear that this backlog is not acceptable, and we are working to reduce it. The rate of incoming cases is increasing, and many of these cases are increasingly complex. It is our experience that requesters come first to the State Department to request information on any and all national security issues. These requests are often a mixture of complex subject matters, including terrorism, armed conflict, foreign government relations, security, and diplomacy. These complex requests require multiple searches throughout the State Department and throughout often any of our 275 embassies, missions, and consulates around the globe, often involving the review of highly classified or highly sensitive material, as well as in-depth coordination with other federal agencies. The most common complaint we receive from the public is delays in receiving timely responses. Our goal is to do everything we can to complete each request as quickly as possible, with as much responsive information as we can, and our FOIA staff works diligently to make this happen. To address these challenges, the Department has undertaken a number of steps recently to improve records management, including our response to FOIA requests. We are working closely with the National Archives and Records Administration. Secretary Kerry has focused attention on FOIA and asked the Inspector General to review these issues, and we have directed more resources towards FOIA processing. Working with NARA, we have ensured that we are capturing records appropriately. In 2014, the State Department adopted the NARA-approved capstone approach to preserving emails, which captures all senior emails, and we started that in 2015. This program has been expanded to over 688 senior State Department officials, including Secretary Kerry, and we will deploy a tool to search these captured materials by the end of this calendar year. The increased use of email, however, strains our decades-old records management systems, but we are on schedule with the additional resources we have deployed and through the assistance of all the work Ambassador Jacobs has done to meet NARA's December 2016 deadline to be able to manage our email records electronically. Efforts by Secretary Kerry. Early this year, the Secretary sent a department-wide notice reminding employees about their FOIA responsibilities and the need for transparency. We are training in enhanced ways our employees on records preservation. In order to focus a dedicated high-level review on these issues, last September, the Secretary appointed Ambassador Janice Jacobs, as I have mentioned, as our transparency coordinator. She is focused solely on records management improvements, including FOIA processing, by moving from a 20th century paper-based system to a modern electronic system. Ambassador Jacobs can, in response to any of your questions, describe her efforts to identify procedural, bureaucratic, and technological solutions. The Inspector General's review. Last year, Secretary Kerry asked the State Department's Inspector General to explore those issues. The State Department IG has issued 4 reports with recommendations for improved records management, including FOIA. And all of the OIG's recommendations are resolved, and we have implemented the majority of them. The others are still in process because of time and resource constraints. In January 2016, the OIG found weaknesses in the FOIA processing by the Executive Secretariat, which the Executive Secretariat has acknowledged. Improvements have been made so far, including establishing written procedures for FOIA searches, including emails, increased training, better oversight by senior staff, and the establishment of metrics. The Inspector General's May 2016 report concerned the email practices of 5 Secretaries of State and shortcomings in how emails were preserved in the past. It is clear that the Department should have done a better job in preserving emails of Secretary of State and their senior staff going back several administrations. The Department is much better situated today than during the historical periods reviewed by the OIG. By early 2015, we have already taken a number of important steps. For instance, as noted, NARA and the IG both agree that past preservation problems of Secretary Clinton and her immediate staff were mitigated by the production of emails to the Department. We then worked diligently from May 2015 to February 2016 to release more than 52,000 pages of former Secretary Clinton's emails. These emails are now a part of the Department's permanent records and are available on our FOIA website for the public to see. We recently received additional Clinton emails from the Federal Bureau of Investigation, which we have begun processing. And as noted, State is automatically archiving Secretary Kerry's emails through the NARA-approved Capstone program, along with 687 other senior officials. Increased resources for the FOIA office. The Department has reallocated and reprogrammed from $18 million in 2014 to $26.2 million in 2015 and $32.5 million this year. Over the past year, the FOIA office has added 25 additional full-time positions and converted another 25 positions from part-time to full-time. This comes at a time when the Department's operational funding has increased 25% in constant dollar terms over the last 5 years. We're taking it out of Hyde. While we have had a dedicated FOIA requester service team to answer questions about specific status requests, a new FOIA public liaison officer joined the State Department in May to enhance our ability to be responsive to the American public. Have these steps made a difference? Yes, we are beginning to see results. In fiscal 2014, we achieved a 23% reduction in our appeals backlog by streamlining our case processing. In fiscal year 2015, the Department closed 9 of our 10 of its oldest FOIA requests. Later this year, we plan to start posting nearly all of the documents released through FOIA, no matter who the requester was, on our public website. This will result in more material on broader ranges of topics, potentially reducing the need for anyone to file a new request for information that has in fact already been reviewed. The Department is committed to finding more ways to streamline the FOIA process and to reduce our backlog. We look forward to exploring this issue with you today. Mr. Chairman, that concludes my statement. I have a written statement that I would ask to be included in the record.
Absolutely.
And I and my colleagues are open to your and the committee's questions. Thank you, sir.
Thank you, and I'll recognize myself. Let me address the Secretary Powell issue. Here's some important differences. First of all, the Inspector General, who we rely on heavily, was able to go back and speak with the former Secretaries of State, except Hillary Clinton, who refused to be engaged with the Inspector General. In Secretary Clinton's case, this is the only case that I'm aware of where there has been an accusation of a destruction of documents that were under subpoena. Mr. Comey, the FBI director, came and testified before this committee that they didn't look at any of the comments that Secretary Clinton gave under oath. And I would also point back to the January letter of this year where we asked the State Department to look back 15 years, not just picking on one, but 15 years, which is a long, I think, exceptionally long time, but looking back, and certainly emails have changed. And finally, I would just suggest that I think there are legitimate concerns about retroactive classifications, over-redactions, those types of things. And I'm pleased to report to the committee, because I think Mr. Cummings has some legitimate concerns, that we're going to get a chance to question those people on Monday. That's why we're doing the hearing. It is an embarrassment that the unclassified documents that are residing in the SCIF, unclassified, are only able to be reviewed by members of this committee, the Appropriations and Judicial Committee. If you reside in another committee and are a member of Congress, you are prohibited by this administration from looking at unclassified documents. I don't know how to explain that, and I think it's absolutely wrong. Mr. Finney, you are on the front lines I know the management team at the State Department didn't want you to be here because we had to issue a subpoena to be here, and I don't take that as you in your personal capacity making that decision. But nevertheless, we're glad that you're here. You have been in this position since 2006. You didn't ask for this. I'm very sympathetic to the idea. You haven't testified before Congress. All I ask you to do is just be truthful, tell us the way you saw it, what happened, and we will do everything we can to make sure that you get your story and your version of what happened out there. When did you first know that there was a problem? Just go ahead and move this microphone up close, and there you go.
First of all, sir, I want to thank you for giving me the opportunity to come forward. I've always wanted to speak the truth. At this particular situation in the comfort zone in this area is different.
Sure. So go ahead. When did you first know there's a problem?
I noticed a problem as far as with records.
Yes, with Secretary Clinton. Yes, in her records.
The first time I noticed a problem, when you look at that, is basically when we noted that we had received some documents. There was initially a letter that went out, and once we had started receiving documents from Secretary Clinton, that's when we realized.
When was that?
I couldn't tell you the specific date.
Yeah, I mean, I don't expect you to get the exact day of the week, but roughly when was that?
I couldn't tell you the exact time. I just know that when we had actually started receiving the actual documents.
Was that after she had left?
Yes, sir.
Did you raise any concerns prior to that? Any questions about did she have a .gov account? Ms. Lang evidently said in a deposition that you did. Do you raise concerns?
Yes, sir. The concern was, and basically was that when she came on board, you know, they asked the question, will she have a state.gov account? And I was told she would not. And also, that was something that was not uncommon because the secretary prior to her did not have a state.gov account. And also the secretary prior to that previous secretary did not have a state.gov.
So the fact that you weren't getting any records from Hillary Clinton, did you ever raise that question, that concern? Were you told to, what did they tell you to say or not say about that?
No one told me anything to say or not say. Again, because she didn't have a state.gov account, that was something that was not abnormal because previous secretaries did not have state.gov accounts. The records that we were receiving were placed into our repository, which is the Secretary Tracking and Retrieval System.
But you got the Secretary Clinton dump of 55,000 pages almost 2 years after she left, correct?
You could say that, not knowing the exact time frame, sir. I just said, yes, we did receive them.
Okay, I believe that was December 5th of 2014 when Mrs. Clinton, Secretary Clinton, returned 55,000 pages of emails. Has the State Department, after December 5th, 2014, has the department received any additional Hillary Clinton work emails that were federal records?
After the 55,000, that's what you're saying specifically?
Yes.
Recently, my office was involved in some records that they had just recently received. But in that particular case, the only purpose that I was involved with was really just looking at the records, seeing if they were personal or work-related. And that was the reason why we got involved in that process, because the department was receiving so many records and the staffing was lacking.
So, Ms. Lang, how many records did the State Department receive after December 5th, 2014?
I'm sorry, can you be more specific? Are you talking about from Secretary Clinton, from other former employees?
No, I'm talking specifically about Hillary Clinton work emails that were federal records. How many did you get after December 5th?
The Federal Bureau of Investigation has transferred a number of documents to the State Department.
And what is that number? Do you know the number?
Those are still undergoing a records review.
Was it 17,448?
My office in the Executive Secretariat staff is not leading that effort.
So who is? Who knows this number? Ambassador Kennedy?
Mr. Chairman, we've received a number of disks from the FBI. We are in the process of inputting them into our classified analysis system and counting them. And we know of 14,900 odd documents, and the FBI has mentioned that there could be tens of thousands others in the string of disks that we're processing now.
And all of those came after December 5th, 2014?
All of those, Mr. Chairman, were received within the last month.
Ambassador Kennedy, on May 22nd, 2015, you asked, as representative of the State Department, you asked Secretary Clinton's attorney, David Kendall, for an electronic copy of the 55,000 pages of emails. When did Secretary Clinton provide the electronic copy to you?
Intervening in that thing, Mr. Chairman, the FBI then took possession of all the electronic material that Mr. Kendall had, to the best of my knowledge.
So did Secretary Clinton fulfill your request to return the federal records via electronic format?
The Secretary Clinton's attorney, to the best of my knowledge, provided that electronic material to the FBI.
Or it was seized, one of the two. But I'm asking, it's kind of embarrassing that you had to ask them to return it in electronic format. They went and printed all this stuff out and gave you hard copy. So did they ever give you an electronic copy per your request?
To the best of my understanding, Mr. Chairman, they no longer have an electronic copy because it's in the possession of the FBI.
Because it was seized, right? Yeah. So, and you have since asked the FBI to turn over that?
We have asked the FBI to provide us with any material that they have in their possession that may be federal records. As I mentioned a moment ago, Mr. Chairman, they have provided us with a number of disks. We are loading that system, those disks, into our electronic system so then that we can, first of all, disaggregate the time periods, because there are potentially records there prior to when she was Secretary of State and after when she was Secretary of State. Secondly, because this is their recoveries from her servers, there could be material in there which are federal records and material which are not federal records. So we have to disaggregate those, and then we will process all the federal records as we would do for any federal record.
So what number are you up to now, do you know?
As I said, right now we're up to 14,900 documents that we are reviewing in both the two stages of disaggregation first.
Okay. Well, last question. I've exceeded my time, but how do I get Hillary Clinton's calendars? Why does that take so long? The original FOIA request came in 2010, and you're arguing in court that you still can't get it done by the end of the year. A judge has had to intervene to force you to produce calendars. How difficult is a calendar? Who's in charge of that, by the way?
Mr. Chairman, when we have 30,000 FOIA requests pending, we also have requirements under statute to do what is called historical declassification, in which we have moved 26 million pages in the last 5 years.
Okay, wait. All I'm trying to talk about is Hillary Clinton's emails, or Hillary Clinton's calendars. I would like to see, as chairman of the Oversight Committee, I would like to see Hillary Clinton's calendars. When can you provide that to me?
I will find a time and get back. I will find when that is and get back to you.
When will you get back to me by? By Tuesday?
By Tuesday, I can give you an idea when that information might be available. If I might, sir, the AP request was actually, for the calendars, was actually part of a larger swath of 6 FOIA requests that were engaged in.
Okay.
And if I might, one other thing, a point that I think is relevant here and also addresses a point that Ranking Member Cummings made, is that the way the law is constructed now, we are required to produce in response to a FOIA request within 20 days. Given the volume of request, given the complexity of request, given the classified material, given our other statutory document requests for the Foreign Relations Series, the historical declassification, there is simply no way, Mr. Chairman, that I can deal with every government agency and 275 posts within 20 days. That is simply a physical impossibility. That's why we're being sued, because I cannot, literally, unless I turn the entire State Department off of every national security mission it had and put it exclusively on FOIA. Eventually, I would produce no new documents, and I wouldn't have a FOIA problem. But there is a true resource, time, and other issues that have to be dealt with here, sir.
So just to be clear, I would like to know how many different versions of calendars Hillary Clinton has, and I'd like to know when you can provide to this committee her calendars while she was serving as Secretary of State. And you'll get back to me in roughly a week. Is that fair?
I can get back to you with a report on how our processing is coming. Yes, sir, because what we were doing for all these FOIA requests, we were treating
My
them all
request is not a
equally.
FOIA request, okay? I don't understand the FOIA part, but I'm just asking you.
I understand fully. I think this becomes the 24th request that this committee has made of us in the last year, and we've already produced.
That's not
like
bad.
108. We've already provided this committee with 185,000 pages of documents, and we will continue to work with this committee to provide more.
Thank you. We now recognize the gentleman from Massachusetts, Mr. Lynch.
Thank you, Mr. Chairman. I do want to point out that you went over a little bit on your time, and I just pray for equal time. Thank you. Mr. Kennedy, first of all, I want to thank the witnesses for cooperating with the committee and helping us with our work. I want to ask you about the former Secretary Powell's emails from his AOL account. And I want to point out that he served between 2001 and 2005 as Secretary of State. And during his tenure, there were 92 million data breaches at AOL. So as Secretary Powell laid out in his own book here, and look, I have enormous respect and admiration for Secretary Powell, and we remain as a country thankful for his courageous service. But what I'm trying to point out is the disparate nature of this inquiry and how we are completely ignoring what Secretary Rice did and Secretary Powell did, and instead the committee, with 9 separate investigations and counting, has targeted Hillary Clinton for her conduct under similar circumstances. So Secretary Powell, on page 109 of his book, might as well plug it, It Worked for Me, In Life and Leadership, Colin Powell, he says, to complement the official State Department computer in my office, I installed a laptop computer on a private line. It was an AOL account. My personal email account on the laptop allowed me direct access to anyone online. So I started shooting emails to my principal assistants, to individual ambassadors, and increasingly to my foreign minister colleagues, who, like me, were trying to bring their ministries into the 186,000 mile per second world. I'm referring to the speed of light, I guess. So a lot of communications, ambassadors, foreign ministers, arguably some classified information in there, but it's being done on a completely private line. The problem is that, unlike Secretary Clinton, Secretary Powell apparently did not save or print out any emails. I have a letter that you sent on November 12, 2014. I ask unanimous consent to submit it in the record. In your letter, you asked Secretary Powell's representative to provide all of Secretary Powell's records that were not in the State Department's record-keeping system. Is that correct?
Yes, sir.
Okay. That would have included emails from his AOL account that were work-related, right?
Yes, sir.
Okay. Did Secretary Powell, well, let me ask you, how many emails did he produce pursuant to your request?
Secretary Powell responded that he did not have access anymore to any of those records, sir.
He didn't have access to them?
Yes, sir.
So the number would be 0?
Yes, sir.
Okay. I have another letter from you dated October 21st, 2015. In this letter, you asked Secretary Powell's representative to contact AOL to determine whether any of his emails were still on their system. Is that correct?
Yes, sir.
Okay. To the best of your knowledge, did Secretary Powell follow up and do this?
We never received a response to that request, sir.
Okay. I got another letter from you, Ambassador Kennedy, dated November 6, 2015. And in this letter, you informed the National Archives that Secretary Powell never contacted AOL. Isn't that right?
That is correct, sir.
Okay. Again, Ambassador Kennedy, in July 2015, the Chief Records Officer for the National Archives asked the State Department to contact AOL directly to determine, and I quote, whether it is still possible to retrieve the email records that may still be present, close quote. Mr. Kennedy, did you ever contact AOL?
Our lawyers advise, sir, that we are not a party to...
Would that answer be a no? Did you contact AOL?
No, sir, we did not contact
Okay, so
AOL.
you got the Chief Records Officer asking you to contact AOL, and you're saying no, and your attorneys are telling you no.
Telling that we cannot make a request for someone else's records from their provider. That request has to be made by them, sir.
Now, at some point, the Inspector General informed you that Secretary Powell sent classified information from his AOL account. Did you contact AOL then?
Again, it's the same answer, sir. We asked,
So he didn't-
we asked that Secretary Powell contact AOL.
So that answer would be no. I mean, but you have a responsibility here, though. You admit that by virtue of your position.
Yes, we contacted Secretary
Let me
Powell.
ask you, how many documents have you given to this committee pursuant to investigation of Secretary Clinton? What's the number there?
I know that it's somewhere probably in the neighborhood of the 50,000
Just 50,000
so far.
given to this committee pursuant to an investigation of Secretary Clinton. I thought we said earlier there were about 168,000.
We have 23 different requests from this committee.
Okay, let me ask you, how many documents have you provided this committee pursuant to our investigation of Colin Powell?
I believe we provided this committee the 3 documents that the
Okay.
that the FBI.
Okay. All right, 50,000 to 3. I think it shows you the lopsided focus here. To your knowledge, has anybody at State Department ever picked up the phone and called AOL about these questions?
As I said in response to your earlier question, sir, we cannot get records of another individual from their provider. They have to do it.
I don't get this. This is ridiculous. This is the National Archives asking you to contact AOL, but you didn't do that. You asked Secretary Powell to contact AOL. He didn't do that. Now, you remember Secretary Powell served at a very critical time. There was dubious information provided about weapons of mass destruction in Iraq that led this country to war. There were some very, very important decisions of enormous consequence in this country at that time. And yet, we are totally silent on that inquiry. Meanwhile, we've got 9 investigations and counting on Secretary Clinton. This is not how this is supposed to work. This committee is supposed to be pursuing the truth, and I have to say that your non-cooperation here, even though it's at the advice of counsel, is, I think, putting the country at a particular point of vulnerability with respect to this investigation. And I just think if we're going to do this, if we're going to put our secretaries of state and our national leaders under the microscope, it shouldn't be just, it shouldn't be just the Democrats under investigation. And that's what I feel is going on right here. That's what I feel is going on right here. And that we've got tens of thousands of documents produced as a result of an investigation of Secretary Clinton, and we've got three documents that you say you've provided with respect to Secretary Powell. This is a sham. This is a sham. And I think the comments of the Republican leader earlier indicated that this whole attempt was to rip down Hillary Clinton and ruin her reputation. That's what this is all about. And we're spending, look, I didn't have to spend any taxpayer money to get Colin Powell's admission that he used a private email system, an unclassified system, to go on AOL that was hacked 92 million times during his tenure. I didn't have to spend taxpayer money to find out what he did. All I had to do was read his book in his own words. And here we are, like I said, the 9th investigation. Now we're going to have another one, I expect, just to rip down Hillary Clinton. And the only reason that we're doing it is because she's running for President of the United States. That's the plain and god-awful truth. That's what this is about. And it's a shame. It's a shame. I yield back the balance of my time.
I thank the gentleman. I would highlight that the letter that we sent in January of this year asked the State Department for the current and past 4 Secretaries of State, and I'd ask unanimous consent to enter this record dated January 19th, 2015, sorry, I said of this year, 2015, into the record.
Mr. Chairman.
Would that be 16 or 15?
Chairman Yield.
Sure.
It's on the document, and I'm wondering, what was the follow-up on that from these folks?
It's incomplete. We don't have all the information yet. We have some, but we don't have
On Colin Powell and Rice and...
We asked for the current and past 4 Secretaries of State.
I just want to know what we've gotten. I mean,
Well, let me get that from the staff. It's a very appropriate question, and we will follow up, but it is incomplete. We did ask for it, not just of this current one, not of the past one, but the past 4. So,
what about AOL? Can we ask them to get us that information? I mean, the fervor by which we're going after Hillary Clinton, it seems like we have so much power over the subpoena. It seems like we would want to get those records. Chairman, willing to go to AOL and
for
try to
first
get there.
order of business, I ask unanimous consent to enter this into the record.
I mean,
Without objection, so ordered. And I will work with you to recover those emails. I just want the federal records. I just
All of them.
All of them. All of them.
Yeah.
If we have to use the power of the committee to extract them and using subpoenas, I'm willing to do that.
You hear that, Mr. Kennedy? We're going to be working with you to get that done.
Yes, sir, Mr. Ranking Member. Could I add one thing?
Sure.
In consultations with representatives of the 4 prior Secretaries of State, neither Secretary Albright nor Secretary Rice used email. They have certified that to us.
Yes, and that's my understanding. I would also note that we rely heavily on the Inspectors General, and there is an Inspector General report on this, and it's very frustrating when the Inspector General, the impartial, in there to do their job, the only person that refuses to interact is Hillary Clinton. And that's just a fact. That's not political. It's just a fact. She won't cooperate with the Inspector General. Even the State Department asks for an electronic copy that was never provided. There is but one investigation that we are conducting relating to what's happening here and these federal records and the potential destruction. We have other inquiries of the State Department, art in embassies, embassy security, things that we're doing in very much a bipartisan way. But let's be careful in how we represent us. There is one investigation.
And that's of Hillary
We
Clinton.
were quiet until the FBI, and when the FBI testified they didn't even ask these questions, it begs the question, and we have a job to do, and we're going to do it.
Mr. Chairman,
Yes,
I know we want
sure.
to move on. I'm looking forward to working with you to get all the records. I think the American people deserve that.
Yeah, I agree.
And I don't want it to be a one-sided, single investigation of Hillary Clinton, because I do think it goes against the integrity of the committee.
I hear you. I hear you.
Mr. Chairman,
Lynch, yes.
just in terms of Ambassador Kennedy's last comment, that he reached out to Secretary Albright and Secretary Rice. Secretary Rice served between 2005 and 2009. That was well into the era of email. Have you checked, did she have a personal account or any? I mean, they certified they didn't use email. I find that very hard to believe.
I have spoken personally with Secretary Rice's attorney, and that was his response, sir.
Okay.
But I believe he was asking about Secretary Albright, too.
Oh, I was asking about Secretary Rice,
But both.
2005 to 2009.
All right, now we'll now recognize the gentleman from Florida, Mr. Micah, for 5 minutes.
Well, again, for the record, Ambassador Kennedy, you did say that they did not use, the 2 previous did not use email. Is that correct?
That is what we have no records.
Okay.
And we have talked to their representatives, Mr. Micah, and to confirm that.
Okay. So, again, the way we got into this, folks, is we had a legitimate investigation into what took place in Benghazi, and actually all of this was discovered sort of by accident. But the fact is, Mr. Finney, how long have you been in your position with state over correspondence and records?
Yes, sir. I came to the State
I
Department.
can't
Sorry,
hear you
need
real
to make it
loud.
real close. There you
Yes,
go.
sir.
What year?
Yes, sir. I came to the State Department in July of 2006.
And the fact is, in 2011, actually, you were first alerted to the use of the secretary. Here's a picture of the secretary. This is an article from a publication that said you identified in 2011 or raised questions about how the secretary was operating. And I guess, did you go to Lang, and Lang made you aware that she was using a private server? How did you find out she was using a private server? You asked the question, was she using a government account? And the response came back, no. Who told you that?
That was told to me by individuals within SESRM. Specific person, I couldn't remember.
But that goes back some time ago. Now, you have an important responsibility. You're supposed to keep the records and correspondence when they leave office. And then you meet with folks. I mean, these are members of Congress. We all have the same obligation. We are custodians or trustees of information, and some of that we cannot take with us. You're not supposed to. In fact, I think it's against the law. Isn't there a statute prohibiting taking that with you? Is that?
Yes.
I'm not an attorney. Okay, yes.
Yes, sir.
You met with Secretary Clinton's staff, did you not? Did you meet with the secretary or just her staff?
Met with her staff, sir.
And is it Abdeen? Was she there and you told them the obligations of what they had to turn over? Did you provide them with that information?
First of all, exactly who was in that meeting, I'll have to go back and.
Okay, but Abdeen, was she there?
Again.
Yes,
I
okay.
can look at that.
But you told them what the obligation under the law and requirements of the State Department are returning information.
Yes, sir, myself and the agency records officer.
At the time, did you mention anything about what was on a private server of business that may have been conducted from in an official capacity?
Again, had no idea of a.
But you told them anything dealing with public information that should be part of State Department documents that you are the custodian for should be turned over to you, correct?
We briefed them about what their responsibilities are, sir. but
And then
also
how long did
certainly
it take? We heard there, again, this request went in as they left. I'm told it took 2.5 years for the first so-called data dump. Is that correct, Ambassador Kennedy?
Could you,
How long before, when did you get the first dump of information from the Clintons?
in December, sir,
Of last year,
December 14.
14? But it was sometime after they left,
That is correct, sir.
2 years after they left. I had 2.5 years.
Sir, if I may,
No, I have a limited amount of time. And were you told at the time that that was all the information? Did anyone tell you that that's all the information they had in data and emails?
If we're talking about the delivery in December
Yes.
of 2014 of the 55,000.
Was there a
pages of
transmittal
material,
document?
We received,
Did the transmittal document say this is all we have, or this is everything we found?
I believe it's something.
I'd like to see that transmittal document, too. But then you tell me the FBI has been dumping additional data to you all, records that they found that they did not provide, right?
What the FBI essentially did, to the best of my understanding, sir, is use forensics to go.
I know, but
into-
my point is that there's a requirement under law to turn over the documents, and this gentleman is responsible. He told them what to do,
Right.
and the terms of the law are the regulations, and they were to comply. They did not.
They, according to their
I want to
attorney,
see
they-
the documents. They
provided-
obviously didn't, and we've gotten dumps of additional information according to the testimony you gave here today. I want to know about the destruction of the hammering of the BlackBerries. Those were personal BlackBerries that the secretary owned. Is that what I'm told? They were not. That was not federal property. Do you know? You're the custodian of the properties or the data. Should they have turned the BlackBerries over if they were government BlackBerries?
First of all, sir, I'm responsible for the records of the individuals who are.
But they also have to give over property. You don't know anything about the hammering of the BlackBerries or whether they're personal. And I also I'd like to know for the record too, the staff BlackBerries that were turned over, if any of those were not turned over, if they were destroyed too. Mr. Chairman, I request that information. I yield back.
Thank the gentleman. We now recognize the ranking member, Mr. Cummings.
Thank you very much, Mr. Chairman. Mr. Kennedy, Ambassador Kennedy, I am extremely concerned, as I've said before, about this whole issue of classification. You've got people being accused of crimes and a lot of it, and it becomes very significant what's classified and what's not classified. I think would you agree with that? It is significant.
Classification is always significant.
Yeah.
Yes, sir, Mr. Ranking Member.
So, Ms. Kennedy, I want to ask you about the instances when experts from different agencies disagree about whether information is classified. I have an email here dated April 10th, 2011. It was written by someone from the State Department Operations Center based on a phone call with Christopher Stevens, who was a special envoy to Libya. It's up on the screen. In the first line of the email, it says, and I quote, SBU per Special Envoy Stevens, end of quote. What does SBU mean?
It means sensitive but unclassified, sir. Unclassified.
So this email was explicitly marked unclassified, is that right?
Yes, sir.
And it appears that the Special Envoy Stevens considered this information unclassified, is that correct?
That is correct, sir.
So anyone reading this email would assume that it was not classified, is that correct?
That is correct, sir.
The problem is that at some point after the email was sent, the intelligence community came in and claimed that it was classified. On September 15, 2015, the State Department sent a letter to Senator Corker explaining that the intelligence community was wrong. The letter stated, and I quote, someone with the intelligence community later, subsequent to its posting, claimed should have been redacted as secret. The letter from the State Department goes on to say that the suggestion that the email should have been treated as classified was, I quote, surprising and, in the department's judgment, incorrect, end of quote. Ambassador, why was it surprising that someone in the intelligence community claimed that this email was classified?
Mr. Chairman, Mr. Ranking Member, there is a common discussion, a common thread that runs between the State Department and the intelligence community constantly, and it's called, in our parlance, parallel reporting. A State Department officer, in the course of his or her responsibility, goes out and talks to people, receives information. There was no classification attached to that information. In other words, the foreign government did not provide us classified information. So it was an unclassified discussion between a State Department officer and a private citizen, a foreign government official, or whatsoever. We file that report, unclassified, sensitive, but unclassified at times. We do not classify it. As this is going on, the intelligence community, through either human intelligence or national technical means, in effect, steals the same information, or something very close to it, and they classify it. And they're classifying it because of the sources and methods involved in obtaining it. So we often see parallel reporting, State Department unclassified reporting and intelligence community reporting talking to the same matter. And therefore, you can have a document that is very close. We looked at this very carefully, and we were surprised, which is why we used that term in that letter, is because a number of the data points in this letter, in this email reporting Ambassador Stevens' conversation, are different, and therefore these are separate. And so but the problem, Ranking Member, of parallel reporting is something we see all the time. But it's actually a good thing, because no government wants to operate on a single thread.
It's a bad thing, though, when the FBI could possibly bring charges against somebody for disclosing documents that they claim to be classified when, in fact, they weren't classified. So, I mean, you can call it healthy all you want.
But, Mr. Ranking Member, what I'm saying is we did not classify it. This is our information in this email that you're referencing, Mr. Ranking Member. This is also information that parallels public press briefings from the NATO press office in Brussels. And so this is unclassified. If the FBI came to us and said, we want to take this as a court action, we would say this information is unclassified. We would so certify it as we have.
So just the last question. Unfortunately, this gets even more confusing because when the FBI issued its report to Congress, they told us that this email was classified at the time that it was sent. Did the FBI ask the State Department whether you consider this specific email to be classified?
I can't give you a particular answer. I know we provided information to the FBI, and this was one of the documents we certified as unclassified.
And so do you have any suggestions as to how we go forward with regard to trying to clear up these because there is no arbiter, is that right? Is there an arbiter? In other words, if you got intelligence saying it's classified, you got state saying it's unclassified, I mean, who arbitrates this? I mean, how do we come up to a conclusion?
As I understand the rules, Mr. Ranking Member, that each agency is the authority over the documents that it produced. The State Department produced this document. The State Department has said it's unclassified, and therefore, de facto, de jure, it is unclassified.
Thank you very much.
Mr. Ranking Member, could I ask, since you made reference to the letter to Senator Corker, could I ask that that letter be entered into the record?
I certainly, I thank you for, I meant to do that, and I asked that the letter dated November 24th, 2015, to Senator Corker be made a part of the record.
Without objections to order.
Thank you very much.
Thank the gentleman. Now recognize the gentleman from Ohio, Mr. Jordan, for 5 minutes.
Mr. Chairman. Ambassador Kinney, how long have you worked at the State Department?
A little over 42 years, sir.
And you're the guy at State Department currently responsible for record retention, maintaining the records, and complying with all appropriate records laws and archive laws. Is that right?
I am the senior agency official, and I have a number of people who assist me in that responsibility.
You sent a letter to four former Secretary of States about records and getting information from those previous Secretary of States. Is that accurate?
Yes, sir.
Well, actually, you sent it to their designees, if I remember correctly.
Yes, sir. They were designees,
their lawyer, their
attorneys, or
yeah,
their senior staff representative.
When did you send that letter?
I believe it was sent in July, August of 14.
I thought
October,
it was
October 14.
Okay, that's what I thought. I had October 28, 2014. And why did you send that letter? What prompted you to decide that you needed, excuse me, to send that letter to the four previous Secretary of State?
Basically, we had been reviewing thousands of pages of documents in response to a number of requests, including requests from this committee regarding the Benghazi temporary special mission attacks. And as we worked through all the documents, all the volume of material involved in that process, we noticed that there was the use of a non-state email address that apparently may have come from Secretary Clinton.
Well, that's not what you told us when we deposed you in February this year. You said you did it because of NARA concerns.
Well, yes.
Is that the same difference?
It's the same difference.
All right.
We saw a potential federal record, and therefore...
So what prompted you was the Benghazi committee request and request from this committee and FOIA request, and that you weren't complying with the NARA law. Is that right?
No, we were looking through documents in response to a committee request.
Okay.
We saw evidence that there might be a federal record from a non-federal source.
Got it.
And that then trips our requirements
Between
to
the
comply
time
with
you
the Federal
knew
Records Act.
when all this prompted you, request and the narrow law and everything else, when all this prompted you, between the time you knew you had to do something different and when you actually sent the letter, did you talk to any of the former secretaries of state, any of those 4, or any of their 4 designees?
Not to the best of my recollection.
Did you communicate with any of them?
Not to the best of my recollection.
Did you meet with any of them or talk to any of them about any subject?
I regularly am in communication with former secretaries. One of the responsibilities of the position of the Undersecretary for Management is to be in contact with former secretaries of state on managerial, administrative support issues. So the answer to that is yes.
Well, let me just get specific. Did you talk to Cheryl Mills between the time you knew you had to do something different with record retention and when you sent the letter?
I don't remember doing so, sir.
You don't remember talking to her at all?
Oh, I don't remember talking to her about the records.
Did you meet with her at all in that time frame?
Cheryl Mills was and remained beyond the departure of Secretary Clinton as the special representative for Haiti. And I had a number because of the importance.
So you told us in
Haitian
February you had lunch with her in this time frame and you
Yes.
met with her on numerous occasions. Is that accurate?
That is what I'm saying, sir.
Okay. You also said when we asked you, I said, between the time you learned that you needed to do something different as far as record retention goes and when you actually sent the letter, you had numerous conversations with Cheryl Mills, but you're saying none of them dealt with this issue.
That is correct, because...
In fact, you answered me and you said this, I never tipped her off. Is that accurate?
Could I
I'm just quoting
answer,
back
sir?
what you said to us in that deposition.
I'm not changing my deposition one item, but 2 things, sir. One is,
Can you give me a look?
I was not brought up to date immediately on the fact that my colleagues and staff had come across this one email thing and then were researching through the material. That was not brought to my attention much later.
Here's what I want to get to. The FBI released their report last Friday. They say on page 15, during the summer of 2014, State Department indicated to Cheryl Mills a request for Clinton's work-related emails would be forthcoming. And in October of 2014, the State Department followed up by sending an official request to Clinton asking for her work-related emails. Now, you just said in February when you were under oath and when you were deposed in front of the Benghazi Committee that you never tipped her off. But somebody tipped her off, because during the summer of 2014, she got a heads up that this letter was coming. Do you know who tipped her off?
No, sir, I do not.
And it wasn't you, Ambassador Kennedy.
Well, not to the best of my knowledge, no, sir.
Ambassador Kennedy, were you interviewed by the FBI?
Yes, sir.
Ambassador Jacobs, did you tip Hillary Clinton off in the summer of 2014 before this letter?
No, sir, I did not.
Were you interviewed by the FBI?
No, I was not.
Ms. Lang, did you tip Hillary Clinton off or Cheryl Mills off in the summer of 2014?
No, I did not, sir.
Were you interviewed by the FBI?
No, I was not, sir.
Mr. Finney, did you tip Cheryl Mills off?
No, sir.
Did you tip Hillary Clinton off?
No, sir.
Were you interviewed by the FBI?
No, sir.
So somebody who was interviewed by the FBI told the FBI we tipped her off. Have you done an investigation, Ambassador Kennedy, and who might have tipped off? I mean, here's what this gets to. Once again, Hillary Clinton gets treated different than anybody else. She got tipped off. I don't think Ambassador Powell got tipped off. Have you started an investigation, Ambassador Kennedy, and who might have tipped Hillary Clinton off before she got the letter requesting
No, sir,
these documents?
I have not.
Any idea who did tip her off?
No, sir.
I yield back.
Thank the gentleman. We'll now recognize the gentleman from Pennsylvania, Mr. Cartwright, for 5 minutes.
Thank you, Mr. Chairman. Ambassador Kennedy, I want to ask you some questions about the 3 emails out of the 30,000 that FBI Director Comey referenced that supposedly had some kind of classification markings on them. And of course, if anyone's scoring along at home, that means 29,997 emails produced with no markings whatsoever, not even defective or incorrect classification markings. I want to talk about the manual on how you properly mark a classified document. Executive Order 13526 and the directive implementing it require classified documents to be marked in a certain way. The document must identify the original classifier, correct, Ambassador Kennedy?
That is correct, sir. There is in effect, a 4-line marking that must go
It
on
must
all
identify the
classified documents.
agency of the office of origin, correct?
Yes, sir.
Must identify the reason for classification, correct?
Yes, sir.
It must identify the date for declassification, right?
Yes, sir.
And classified documents typically have to have a banner or a header at the top and bottom that say classified along with the level of classification. Am I correct in that?
Yes, sir.
Okay, so 5 different requirements in the manual, and the 3 emails that Director Comey testified about had none of these indicators. Am I correct in that?
That is correct,
Not
sir.
one of the 5 required marking requirements. Am I correct in that?
That is correct, sir.
Okay. The 3 emails had none of them. As a result, Director Comey, sitting where you're sitting right now, testified that it would be reasonable for somebody looking at a document with none of these required markings immediately to infer that they were not classified. Are you aware of that testimony?
I am aware of it, sir.
And do you agree with Director Comey that someone who is familiar with properly marking classified documents would reasonably consider such a document without any of these 5 requirements not classified?
I fully agree with the Director.
Now, State Department spokesman John Kirby said that the parentheses C markings, the one that refer to confidential, the lowest level of classifications, on those 3 emails, John Kirby said those markings themselves were in error and they were not, quote, necessary or appropriate at the time they were sent as an actual email, unquote. Is that your understanding as well?
Yes, sir.
Well, I want to show you one of these emails, and it's dated August 2, 2012. The marking, and we have that up on the screen for you as well. Do you have that, Ambassador?
I do, sir.
All right. The marking that Director Comey referred to is the C in parentheses at the beginning of the email, and that's the marking that the State Department said was a mistake. Do you see that?
Yes, sir.
And then 4 paragraphs follow. Do you see them?
Yes, sir.
Each of the paragraphs says SBU, and we've covered that in today's hearing. SBU means sensitive but unclassified, right?
That means, yes, sir, and that means it does not have to be moved in classified channels.
So every one of these 4 paragraphs in the bulk of this email are sensitive but unclassified, right?
Yes, sir.
Okay. So this email is in fact unclassified, and it always has been, hasn't it?
Yes, sir.
Now, did the FBI consult with you about the classification status of this email?
They did not consult with me personally. I know the State Department did provide some input to the FBI, but their decisions are their decisions. Their writings are their writings.
When you say there, who do you mean?
The FBI, sir.
All right. Do you know why the FBI did not consult with you about the classification status of this email?
I would have to check, Congressman, to see if they consulted with someone else at the State Department. I know they did not consult with me. But as you correctly point out, the subject line there does not have any classified material in it, nor does the text of that. And even the redactions that are there, the redaction B5 is a redaction for deliberative process, not for classification. So this document is unclassified.
I thank you, Ambassador, and I yield back.
Thank the gentleman. We'll now recognize the gentleman from Michigan, Mr. Wahlberg, for 5 minutes.
Thank you, Mr. Chairman, and thanks to the panel for being here. Mr. Feeney, when did you first become aware of the extent to which Secretary Clinton relied on private server emails to address her conduct, her responsibilities in State Department business?
Sir, I couldn't give you the actual date and time frame, but I do know that when we had started receiving the actual documents at the State Department, that's when I come to realize that she is using another device other than...
Do you recall a January 2009 FOIA request for correspondence related to Secretary Clinton?
Sir, without looking at the case, I couldn't specifically know.
But you would identify the fact that you have logs, so if you can't recall it, right here, there's a January 9th of '09 request for information on correspondence from Secretary Clinton. So you would be able to go back, whether you recall it right now.
Yes, sir. If we received it in the Executive Secretariat, then we could go back.
On the basis of that, did you review email correspondence from the Secretary in putting together the response to this January 2009 request?
No, sir, because we did not have emails. She did not have a state.gov account, so all we could search was our records that we had, sir.
So you then, as I understand it, did not realize the extent to which the Secretary was using her private email server. And on the basis of that, you're saying you couldn't do anything about it?
Again, sir, did not know that she had a server or other email accounts that she was using until we received it in the department.
Well, how was, if this request was made in 2009, how was the department able to close a request for correspondence covering Secretary Clinton when the department did not have access to all of the email correspondence from the Secretary?
Again, sir, I would have to see the specific request and see what they were asking and see if it in fact was received.
But they did ask. You've got a log of that.
Again, sir, I would have to see if we in the Executive Secretariat received it, because when FOIAs come in, they do not come directly to the Executive Secretariat. They come to a bureau.
Now that you know, is the department reopening requests that would encompass the Secretary's emails that were closed prior to disclosure, that she was using her private server, private emails for conducting official business?
I'm not able to answer that question, sir, because I'm only responsible for the Executive Secretariat.
Who would be responsible for that? Mr. Kennedy, now that you know it?
Now, that is why, Congressman, that we have posted all of the 52,000 emails we received on the State Department's public website, so that if there was an email that we now have, but we did not have then, and therefore since we did not have it, we were telling the truth in response at that moment. If anyone thinks that one of their inquiries did not get a full response, we have posted all that material, all the 52,000 odd documents, to our public FOIA website in a searchable form, so that we can be, in effect, retroactively responsive to any earlier inquiries that we did not have records of then.
Wow.
So we have anyone who had made a request, they can now go to our website, and all the 52,000.
So we got the requests.
Pardon me, sir?
We have the request then on the website. That's what you're saying.
No, we have the documents on the
Okay.
website. All 52,000 documents are on the website. And therefore, if we did not respond before, because we did not have the record then, and we have the record now, the 52,000, we put all 52,000 of them up on the State Department public website, accessible to every member of the public.
Again, Mr. Chairman, I think this is the reason for this hearing, isn't it? The sloppiness, the messiness, and the ability for a Secretary of State to do something that shouldn't have been done. Mr. Feeney, do you recall a FOIA request from August 27, 2010 that specifically requested email sent to Hillary Clinton?
Not right offhand, sir.
As of January 25, 2011, this request had been marked pending. Given that this FOIA request specifically asked for records related to the emails sent to the Secretary, your processing should have, as I understand, included a review of the Secretary's inbox. Did that processing take place?
Again, sir, I'll have to see if, in fact, the Executive Secretary actually received the request.
Mr. Chairman, I yield back.
Thank the gentleman. Before he does that, if he'd yield for a second, there was a choice. The Secretary had a choice. She chose to not abide by the rules of the State Department, and she went off and, for her own convenience, created her own account, her own server, and her own mess.
Federal records.
Federal records. There was a choice there. It was not a mistake. A mistake is when you accidentally put the letter E at the end of potato. This is a conscious decision to go a different route. And if you want to protect yourself and make sure that there's not a reclassification problem or something else, then use the .gov account. That's why it's there. It's safe and secure. And by the way, there are two systems at the State Department. You can't just take classified information and hit forward. That doesn't work like that. So we got to get into the depths of this. It's in part why we have the hearings next week, but it was a very conscious choice, and she chose not to use the safety, the security, the expertise of the State Department. She put the country and her federal records in jeopardy and created this mess that these poor people are going to have to clean up for years to come. We'll now recognize Mr. Liu of California.
Thank you, Mr. Chair. Ambassador Kennedy, it's true, isn't it, that the Freedom of Information Act does not apply to members of Congress?
To the best of my knowledge, sir, that is true.
So let me just let that sink in for a moment. We in Congress have passed this law asking other federal agencies to meet these standards that we ourselves are unwilling to meet. It is pure hypocrisy. It is a double standard. But it gets worse in this case. Did you know, Ambassador, that all members of Congress get security clearances?
I believe so, yes, sir.
And we get it not because we go through a background check, but because we happen to win the most number of votes in our district. And as members with security clearances, we get to have private email servers. We can have one private email server. We can have 5. We can have 27. We get to have private email accounts. We can conduct official business on our private email server, on our private email account. So I'm not going to continue to participate in the hypocrisy of today's hearing. Instead, I'd like to use the remainder of my time to talk about an issue that actually matters, and that is the slaughter of children and civilians in the country of Yemen being enabled by the U.S. Department of State. And Ambassador, as a principal advisor to John Kerry and as an undersecretary, I'm sure that you know that last year the State Department started providing material assistance to a Saudi Arabia-led military coalition in the country of Yemen. Are you aware that numerous human rights groups, such as Amnesty International, Human Rights Watch, as well as reporters on the ground, have documented numerous war crimes being committed by this Saudi Arabia-led military coalition?
Congressman, I have seen references to that in the press, but if I might, not an attempt to avoid your question, because I would be glad to arrange for someone to. There are 6 undersecretaries at the State Department. I'm the undersecretary for management. Right. My writ is rather large, but it does not. It does not encompass political military activities, foreign military assistance, or others.
I understand.
And I'll be glad to work with you, though.
I understand. As a member of the minority party, I do not get to set the agenda, but I have 4 State Department officials here, so I'm going to ask these questions. Are you aware that Amnesty International published a report documenting at least 33 cases where the Saudi Arabia coalition, with the assistance of the United States, targeted and killed civilians, many of them nowhere near military targets? And you can just answer yes or no.
I have not seen that report,
Okay,
sir.
right. Are you aware that just last month, this Saudi Arabia-led coalition targeted and killed children at a school? There were 28 kids, 18 were injured, 10 were killed, some were as young as 6, 7, 8 years old. Are you aware of that?
No, sir, I am not.
Are you aware that this Saudi Arabia-led military coalition struck a 4th hospital facility last month, this time a Doctors Without Borders hospital, killing numerous patients, doctors, and hospital staff? Are you aware of that?
I think I may have seen that in the newspaper, sir.
You would agree with me, wouldn't you, that it is a war crime if you target and kill civilians nowhere near military targets?
I am not a lawyer, sir, but obviously the direct targeting of civilians without any other justification is certainly not acceptable.
Thank you. And you're aware that the United States is providing refueling of Saudi Arabia jets, logistical support, intelligence, and other assistance, correct?
I am aware that we are assisting the Saudi Arabian forces to combat terrorist activities in Yemen. Yes, sir.
And the State Department has now proposed yet another sale of billions of dollars of arms and munitions to Saudi Arabia that the State Department noticed when Congress was in recess, so that we would have very little time to act on it. Is that correct?
I am not aware of that congressional notification, sir, but I do aware that we work with the government of Saudi Arabia to help combat terrorism in the Middle East.
Combating terrorism is fine. Using war crimes to do it is not fine. Are you aware that a person who aids and abets someone who is committing war crimes can also be guilty of war crimes?
No, sir, I am not a lawyer.
Okay. So my recommendation is that you check with the lawyers of the State Department and you ask them the question, why is the State Department looking like it is aiding and abetting the commission of war crimes in Yemen? And with that, I yield back.
I promise you, sir, that I will arrange for the appropriate senior official of the State Department to be in touch with you.
And to Mr. Liu, I would I'd also add that we have, for a couple months, been trying to get Secretary Kerry to come appear before this committee, sensitive to his schedule, but we're at the point where we may have to step it up a notch. But it is the intention of the committee to have the Secretary come to answer. So hone those questions, and hopefully that will happen in the next week or two.
Thank you, Mr. Chair.
Thank you. We'll now recognize the gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. Mr. Finney, I had a series of questions for you that I'll submit to you in writing. I'm going to have to deviate from what I'd planned to do because of the ranking member's opening statement, which I found instructive, if not predictable. So I want us to summarize for just a second. Secretary Clinton said she followed all State Department rules and regulations, but the truth is she did not. Secretary Clinton said her unique email arrangement was approved by the State Department, but it was not. Secretary Clinton said she used one device for convenience, but she did not. Secretary Clinton said she did not send or receive classified material, but she did. She said she turned over all of her work-related emails, but she did not. She said her attorneys personally reviewed each email, but they did not. So when faced with a series of demonstrably false statements, utterly impeached by both fact and logic, the ranking member did what lots of criminal defense attorneys do, which is blame the investigator. And when that didn't work, they throw the Hail Mary pass of all criminal defense attorneys. Other people did it too. Which brings me to General Colin Powell, one of the most respected people in our country's history. You know, Secretary Clinton told the FBI, and I'll concede, she says different things to the public than she says to the FBI, but she told the FBI that Colin Powell's advice had nothing to do with her decision to set up her unique email arrangement with herself. Now, I'm going to say that again in case anybody missed it. Secretary Clinton told the FBI, under penalty of not telling the truth, that Colin Powell's advice, email, had nothing to do with her decision to set up that unique email arrangement with herself. Now, I will say this in defense of Mr. Cummings. I understand why he may not believe her. I understand that. I understand why he may have credibility issues with anything that the Secretary said. I get that. But I think it would have been fair when you are using your opening to criticize Colin Powell to at least point out the person you're trying to defend doesn't even say Colin Powell was the impetus behind her decision to have that unique email arrangement with herself. So let me ask you this. Secretary Clinton was asked, because she frequently says 90 to 95% of her emails were in the State Department system. Have you heard her say that?
Sir, I can't recall.
Well, it won't take you long to find it. She says it a lot, or she said it a lot. And then she was asked, Who told you that? Who told you that 90 to 95% of your emails were in the State Department system? You may find her answer interesting. We learned that from the State Department and their analysis of the emails that were already on the system. We were trying to help them close some gaps. I like the word gaps. I guess if you consider the Grand Canyon to be a gap, then yes, there were some gaps in her email. Did you have 90 or 95% of her emails on your system?
Again, sir, the only emails we would have is what has been provided recently, which was that 55,000 that we got.
Well, no, I'm going back before that, Mr. Finney. She said you already had them before she gave them to you. You already had 90 to 95%. Was that true?
Again, sir, the emails that we're looking at, talking about the state.gov emails, she did not have a state.gov account. And as far as the emails that we received from her came at that time frame when it was turned to the department and it was processed by a bureau.
But she made this contention before she ever returned them. She said you already had 90 to 95%. She was just helping you fill in some gaps. If you had 90 to 95%, why weren't you complying with FOIA?
Again, sir, what I have in our system is what received by a bureau.
Let me see if I can put that in South Carolina terms that I can understand. If she said that you already had 90 to 95% of her emails before she ever returned them, that ain't true.
Sir, if I may say this, unless she's talking about the files that were sent to other individuals within the State Department, sent to their state.gov account.
Well, how does that capture personal-to-personal emails? And how about the 14,000 that she didn't turn over? Did you have those?
Again, sir, what you're talking about here.
Oh, I understand her position.
Yes, sir.
The fact that I didn't keep them doesn't mean that whoever I sent it to didn't keep it. I get that. What if it's private to private? How are you supposed to have Sidney Blumenthal's emails if it's private account to private account? How do you have that?
Sir, if you look at what we are doing today, in accordance to the Federal Records Act of 2014 that was amended, it requires that if an employee uses their Gmail account or private issued account, they're required by law to send that email to their state.gov account. That was amended in 2014, and that is what I'm briefing and the State Department briefs today.
That sounds like it was a couple of years too late, but I'm out of time.
Thank the gentleman. Now recognize the gentlewoman from the Virgin Islands, Ms. Plaskett, for 5 minutes.
Thank you very much, Mr. Chairman, and good morning to you all. Thank you for being here. I believe that the ranking member, and I don't want to get into his head, was pointing out the disparity between the two secretaries, not to absolve Secretary Clinton of her responsibility, because as we've all seen in testimony that she's given, that she has taken full responsibility for her own emails, but to point out the disparity and the bias in this own committee in how it treats different secretaries of state. I want to ask you about some emails that I hope you have received from other secretaries. Ambassador Kennedy, do you have any emails from the Secretary of State who was the Secretary of State in December 2002 or January of 2003?
No, no, I do not.
And that would be Secretary Colin Powell, would that not?
Yes, ma'am.
Those are very interesting emails, I would think, because that would be the 2 months before he gave testimony on February 5th, 2003, before the United Nations, saying that there were weapons of mass destruction, which has resulted in the death of almost tens of thousands of Americans with the Iraq War. But this committee, which says that it's investigating these breaches and these emails because they're concerned with the lives of Americans, don't seem to be concerned with the email traffic that went on that precipitated that testimony, which led us to war. They're not concerned at all with those emails, but they're concerned with Secretary Clinton's emails. How many emails have you received from Secretary Colin Powell?
The only ones that I'm aware of that are in our possession are the documents that you just handed out, that we received via via the FBI in an interchange between Secretary Clinton and then former Secretary Powell?
I've got a great one from that exchange, which is an email exchange between Secretary Clinton and former Secretary Colin Powell from January 23rd, 2009. And we can put that up there. And I'd ask unanimous consent to submit that into the record. This is 2 days after Secretary Clinton was sworn in, when she asked Secretary Powell for advice on how he used his personal mobile device in his office at the State Department, which is a secure space for classified information called a SCIF. So, Ambassador Kennedy, can you explain why diplomatic security does not permit anyone to bring a BlackBerry or cell phone, an iPhone, into a secretary's office at the department?
We operate under rules laid out by the then former director of the CIA, now the director of the Office of National Intelligence, and you do not ingest certain documents into a secure compartment information facility because they may pick up signals and transmit them out.
Now, Secretary Powell, who everyone, I believe, in the House would admit is an amazing American, a patriot to this country, describes in this email with Secretary Clinton that he used a personal phone line to set up, he quote, to communicate with a wide range of friends directly without it going through the State Department servers. He said he also used that account to do business with foreign leaders and other State Department officials who are using their personal email accounts. Now, this is not to say that Secretary Clinton should have done this. What I'm pointing this out to say is that Secretary Powell, by his own admission in this email, says that he did this as well. And we know that some very, very serious matters were discussed during his time frame, which this committee does not seem to be interested in at all. And Secretary Powell has given how much of his AOL email accounts to you all during your FOIA requests?
We have received no documents from Secretary Powell.
And I heard Mr. Finney say that there is a directive that if an email is sent from a personal email that's related to State Department matters, it should be sent then to a State Department email account.
That is something that was put into effect in 2014 prior to after the amendments to the Federal Records Act. The earlier requirement was that if you sent an email from your personal account, you could either copy it to yourself or provide a paper copy.
And was a paper copy provided from Secretary Powell?
I'm aware of no paper copies.
No paper copy. And when is this committee going to receive that? And when is the urgency that we seem to have for Secretary Clinton giving us this going to, in fact, be given across the board to the other secretary? Secretary Powell explained that he disregarded diplomatic security, the NSA and the CIA, and used his personal mobile device in secure State Department spaces. He says, and I quote, "And the issue was DS would not allow them into the secure space, especially up your way. When I asked why not, they gave me all kinds of nonsense about how they gave out signals and could be read by spies, etc. Same reason they tried to keep mobile phones out of the suite. They never satisfied me, and NSA/CIA wouldn't back off. So we just went about our business and stopped asking. I had an ancient version of a PDA and used it." Mr. Kennedy, were you aware that Secretary Powell used his PDA in the SCIF?
No, I was not. I was not in this position at that time.
Secretary, are you aware of that now?
I am aware of it from having read the email.
Would the secretary who was in your position at that time have allowed that to have occurred?
He would not have.
Thank you.
Thank you, Mr. Chairman. Thank each of you for your testimony. I think part of what my colleague opposite is talking about is a double standard. And so certainly if Colin Powell has emails that belong and should belong to the federal government and the people of this great country, they need to go, you need to go after them, you need to request them officially, and you need to get them. I'm with her on that. Whether it's Colin Powell or Hillary Clinton, they do not belong to those individuals, they belong to the American people. But let's talk about a double standard, because the very email that my colleague opposite just put up actually is an email that she obtained from the State Department in the last couple of days. Isn't that correct, Ambassador Kennedy?
We received a request from the ranking member signed by
7 members, right?
the 7-member rule, yes, sir.
So let me ask you how this happens, because the double standard that I'm seeing here is an incredibly quick response by the State Department when it is responded to the ranking member in defense of this particular hearing, and a slow walk when it comes from the chairman. And let me give you some examples, because in January of this year, the chairman requested information as it related to Hillary Clinton's FOIA request and so forth, and it took 40 days to get a performance evaluation on Ms. Lang. That was the only response in 40 days. All right? Do you find that troubling, Ambassador Kennedy?
No.
Oh, you don't find that troubling?
No, sir, if I could.
No, just, that's good enough. You've responded, so you don't find it troubling. So let me ask, the ranking member, Mr. Cummings, asked for information on Condoleezza Rice and Colin Powell on February the 4th. You got a full response to him in less than 30 days. Isn't that correct?
The difference is you asked for
I
one.
didn't ask for the difference.
You asked for one document.
All right, well, we'll go there.
It's very easy to find one document.
All right,
but produced 186,000 documents.
Fair enough, Ambassador Kennedy. So let's go to the specifics. On September 2nd, you get a letter from the ranking member asking for Colin Powell's emails between he and Hillary Clinton. I mean, between Hillary Clinton and Colin Powell, the supposedly 7-member request on September the 2nd, and 5 days later, he gets the emails. Do you find that extraordinarily fast, in that there was a FOIA request for that same information that's been outstanding since 2014? So the public asked for it in 2014, the ranking member asked for it 5 days ago, and you got it to him before this hearing. Do you not see a double standard there?
I see two things, Mr. Congressman. One is this is part of the material we just received from the FBI. So we did not have it until last month.
The FOIA request, you sent this information to the person who requested the FOIA as well?
That FOIA, I would have to find out.
All right, because here's the interesting other aspect. You made a caution, and I quote, "The department has concerns about the public release of these documents. FOIA markings and redactions reflect the fact that the documents are currently being processed for FOIA and have undergone an initial review. However, the preparation of these documents for the public release has not yet been completed, but yet they released them. Do you not see a problem with that?"
Mr. Meadows, we try to the best of our ability to respond to committees of Congress. That is a priority.
But it is with unbelievable speed when it fits the narrative that you want to do. So here's my request of you, Ambassador. I've got two. The chairman asked for a very simple request that's been outstanding from the AP about a calendar. It shouldn't be a hard request. It's not 137,000 pages. Can you respond in the same length of time that you responded to the ranking member in 5 days?
The answer to that, sir, is whether or not there is any information that we have to call out on those calendars.
You've been looking at it since 2010 for the AP. I would think that eventually you'd be able to do it 5 days.
Sir.
All right, here's the last one because I'm running out of time. 2 years ago, I asked you a question in Foreign Affairs under sworn testimony. Was it you or Hillary Rodham Clinton who decided to not publish the bonuses for State Department? Because it has to be one or the other, either you or Hillary Rodham Clinton. 2 years later, I'm still waiting for a response. I want a direct response. Was it your decision to make sure that bonuses are not public and not transparent, or was it hers? I'll yield back.
We'd like you to answer the question.
Sorry, the time. The answer is, sir, that I do not recall the question from you, and therefore I humbly apologize. I will get you an answer. My general recollection is there was a decision made government-wide not to publish documents, not to publish bonuses.
Mr. Chairman, to clarify, there is only one of two people who could have made that decision, either you or Hillary Rodham Clinton. Who was it? That's what I want to know.
It definitely wasn't Secretary Clinton. That kind of decision did not go up to her.
So you said you don't know, but yet you know it wasn't her. That's interesting.
Because I would never send an issue of that nature to the Secretary of State, because the Secretary of State, no matter whether it's George Shultz, Colin Powell, or Hillary Rodham Clinton, or John Kerry, does not need to deal with an issue of that stature.
All right, thank you. We'll now recognize the gentlewoman from the District of Columbia, Ms. Norton.
Thank you, Mr. Chairman. You know, the words reform, government reform, are in the title of this committee. So I grow weary when we play gotcha all the time and no reform comes out of the system. I am very interested in what happened here, because I think it does illustrate probably the kind of confusion one might expect in a system that has classified and unclassified. So I'm really looking for what the reform we can get out of this system, and asking you, Ambassador Kennedy, to help me out. Director Comey, for example, testified that there were 30,000 emails that the Secretary provided to the State Department. 2,000 were later determined to be classified. Now, let me tell you the danger I see in that. This is after the fact classification. Now, you know, we always complain about over-classification. But this isn't that. It's after the fact. This is something that should be secret, so it shouldn't be shared. But by that time, who knows how many people have had it shared with them. So I'm trying to come to grips with after-the-fact classification. Do you see a systemic problem when so many members, 2,000, it's a large number there, so they would be senior Foreign Service members, could have been writing information they believed to be unclassified, just to be overturned, God knows when, by FOIA, in which case everybody would say, oops, I just didn't know. Now, and apparently for those 2,000, at least 1,000 people were on these emails. Could I ask you, what advice does the State Department give its employees about the possibility of retroactive classification? Does it warn them that these emails are not classified now, but don't share them because they're subject to being reclassified as classified?
Congresswoman, you've posed a very, very salient question, and if I could address it in two ways. First of all, there is a large amount of information that the State Department receives in course of its business that we call foreign government information. This is information we get from a foreign government in the course of our diplomatic activities around the world.
You mean all of that wouldn't be classified?
Not all of it will be classified. Many of it is not given to us in confidence, and there is not a risk of loss of life if the information came out, but is given to us, and we treat it as unclassified foreign.
Loss of life, I'm not familiar with that standard.
Well,
what about loss? What about loss of face?
Well, I mean that's what I'm getting to, ma'am. This information is given to us, and we treat it as sensitive but unclassified.
Now, as sensitive, does that mean don't share this information?
Don't share this information.
It could be classified later.
No, it's just it's sensitive information because it was received often from a foreign source.
And we're only talking about foreign, are we only talking about foreign source, were all 2,000 foreign source?
No, to the best, we did a little calculation, and it's rough. 2,000 of the 2,100 emails are confidential. We believe that 70% of those 2,000, some more or less 1,400 information, were classified because they contain foreign government information. If you went to the Department of Defense or to the Department of Energy, they have by statute, and the State Department has been asking for a change in the law for several years, that we have asked for the ability to declare that material restricted so we do not have to release it to the public. Because as you rightly pointed out, ma'am, it can be an embarrassment. A foreign government gives us
So it's sensitive versus restricted, what's the difference?
The restricted means we would have the authority under the FOIA to not provide that information to the public.
Does that mean subject to possible classification?
No, it just means that it would be exempt from FOIA. And the reason why we have to retroactively...
yeah, I'm worried about there being...
The reason we have to retroactively classify it is we do not have the same abilities and authorities that the Department of Defense and the Department of Energy can do. They have an ability to say, this is exempt from FOIA. We don't have that. If we had that, my back of the envelope guess is 1,400 of the 2,100 classifications would have disappeared, and they would have been available to the Congress, but because of the sensitive nature of foreign government exchange, they would not have been available to anyone who reads it. And you obviously all realize that a FOIA request doesn't only go to American citizens. Anybody can make a FOIA request.
So this is very important as far as I'm concerned. So the reform here, I would take it, would be that what you're doing, you're being forced to use the classification label.
Exactly. We need the authority to have a foreign government information exemption, and we have asked for that from
Would
the
this
Congress.
require a statutory change?
It does require a statutory change.
Mr. Chairman, please note that, because I do think that is important to know. I'm not sure the committee knew that. That testimony is important for me, and I think it comes out, I think, at a good time when we're trying to find out not only what happened, but what to do about it. Let me ask you finally, have you directed these 1,000 people to do anything about, like, for example, deleting this classified information? Remember, retroactively classified from their systems. Have you asked them, since it's now classified, to make sure it's gone from your system? And indeed, what can you do about it if it's retroactive?
We take certain steps with the highly classified, but for the FGI material, we have not taken that step.
Don't you think you should?
Because those are within our system, and
You mean those cannot be shared anyway?
we have now marked them so they were not going to be released to
Could I just ask one? Should they be deleted or not?
We would not delete them. We would transfer them to another system because we do not delete federal records.
Thank you, Mr. Chairman.
Thank you. And that's a good takeaway. I appreciate, Ambassador, you're sharing that perspective and driving that home with us, so thank you again. We'll now recognize the gentleman from Georgia, Mr. Heiss, for 5 minutes.
Thank you, Mr. Chairman. Ambassador Jacobs, when responding to a FOIA request, who in the State Department is responsible for determining what is redacted?
Thank you for the question. It is the responsibility of the people who work in our FOIA office, which is in our Bureau of Administration, to determine what is redacted.
Who is the lead person, the head? Where does the buck stop?
It's a number of people who are trained and skilled in the FOIA law who do this. There's not one particular person.
Could you provide the names of those individuals for us?
I can.
Okay. Is there a specific criteria that they use to determine what is redacted and what's not?
Yes, sir. It's basically the FOIA law, the exemptions that exist under the FOIA law.
Okay. When responding to a request from Congress, who is responsible for determining what is redacted?
There are different standards that are used for Congress, sir. I think that you get more information than we would release to the public ordinarily.
I'm not so sure that we do. How is the process different between a FOIA request and a congressional request when it comes to what is redacted and what is not?
I think we are guided by the different agreements, arrangements that we have with Congress. Certainly, for releases to the general public, we follow the FOIA law, and I think with Congress, perhaps there are different procedures that we follow.
Do you know what those different procedures are? That's my question.
I'm not exactly sure of all of them. I'd have to get back to you, sir.
Would you get back with me and clarify that issue?
I will do that.
You have been really in charge of your role as transparency coordinator in the State Department. Do you believe the State Department is being transparent?
Yes, sir, I do. I think to the best of our ability, we are committed to openness and to, especially under FOIA, to releasing whatever we can.
Okay, but the question goes beyond FOIA. It goes to congressional requests as well. And it's extremely frustrating. Just for example, I know it's with the FBI, but they just released a 58-page summary to the public, publicly released the other day. I was scanning through it. In fact, I have a copy of it right here. And listen, I understand, Mr. Chairman, I understand fully when there are potential compromises in our national security, I understand the need for redacted material. That is not even in question, I don't believe, with anyone. But the current process seems so arbitrary and just all over the map where and how redactions take place. And frankly, this is an issue that goes across the entire executive branch. And the questions out there are multiple. I'm looking right now with the summary that came out the other day. Ms. Clinton's birthday is redacted. I mean, what is the potential national security threat in that? You can go on Wikipedia and find it. In fact, I did.
Congressman,
that is no, sir.
If I could just ask.
No, I'm not asking you a question right now. I'm expressing frustration in the whole process. The very next sentence, it mentions Ms. Clinton's 5 attorneys, 4 of them by name, but 1 of them is redacted. We seem to be all over the map, and quite frankly, the end result appearance, at least, and I'm not making an accusation, but the absolute appearance is that obstruction is involved many times when it comes to what is redacted and what is not. And how in the world can we do our job of oversight when we're not given the requested information that we need to do our job, or when what is received is so redacted it's difficult to determine what has been really given us and what's not been given. So, Mr. Chairman, I think any reasonable person would frequently look at the material, whether it's through a FOIA request or a congressional request, and have great concerns that information that is needed for whatever requested purpose is not being provided accurately. And this, Ambassador Jacobs, raises a question as to transparency at State as well as other departments. And so, Mr. Chairman, I would just, I hope that we can not only get the material that we've requested, all of it, but I hope also that transparency can occur. It is America that's suffering when we're not allowed to do the job that we've been tasked to do here in oversight. And with that, Mr. Chairman, I yield back.
Before he yields, if the gentleman yield to me.
Yes, sir.
Ambassador Jacobs, you're heading up the transparency, you're the transparency coordinator. What is it that you believe Congress should not be able to see?
Sir, thank you for the question. I am not completely familiar with all of the agreements and arrangements that we have. I do know
But why
that
should there
in
be
general,
any agreements and arrangements?
Well,
What could Congress not see? You were brought in by Secretary Kerry, right, to be the transparency person.
Yes,
So
sir.
you're champion of transparency. What is it that Congress should not be able to see?
I think that Congress should have access to all of the information that they are entitled to. I believe that there are certain restrictions that are
Wait a minute, give me an
privacy.
example. You've been in Foreign Service for 33 years, so give me an example of something that I, as the chairman of the Oversight Committee, or Mr. Heiss, should not be able to see.
Highly classified, compartmented information, perhaps, if you don't
Like-
have the proper clearance.
With SAP information?
I assume so, unless you have the proper clearance.
What else?
Information related to privacy, personally identifiable
Nope,
information.
sorry, got that one wrong. Sorry, we're not, Congress is exempt from the Privacy Act, so try again. What else?
Sir, I really believe that you should have access to whatever information.
But when you get this thing, it's sent to us and it's chock full of redactions. Why?
Are you referring to
No,
information?
we don't
that we've
need the
sent or
whispering here. We'll
FBI?
allow you all to do it. You don't need to kind of whisper in her ear and tell her
No.
what the right answer
The
is.
question was whether this was information from the FBI or from the State
I'm asking
Department.
from the State Department.
What I can do is offer to come up and with a.
You're here right now.
I understand, sir, that this is.
Ambassador Kennedy, come on, you've got probably the most experience here. Give me an example. What is it that Congress should not see?
I think that not every member of the congressional staff should be entitled to.
I didn't ask about
No.
staff. I said members of Congress.
Okay. Then, Mr. Chairman, the only thing that I believe is valid is internal executive branch deliberations leading to a decision.
And that
I think that is a prerogative of the Congress to have its deliberations secret, and it's a prerogative of the executive branch to arrive at a position and then come up and defend that position wholly and fully before the Congress, but not necessarily all the internal puts and takes that went into it before an executive branch decision was made, sir.
And there is the President can claim executive privilege. There's a process to do that where the President actually has to sign a document invoking that executive privilege. Mr. Cummings.
Yeah, just real quick. Ambassador Kennedy, I'm just curious about something Mr. Heiss just asked. Why would a birthday be redacted? I'm just curious.
Private.
You were trying to answer it, and I was just wondering what you were going to say.
We think that names of spouses, names of children, birth dates, Social Security numbers, that information is not necessary for the conduct of any business, and there is always the possibility of spillage. I am not accusing any member of Congress or any staff member, but we desperately try to make sure that information that is protected under the Privacy Act is used only on an absolute need to know.
The Privacy Act does not apply to Congress, and what you're doing is you're conflating FOIA with congressional requests. We have a SCIF. We deal with classified information. We've exhausted this for right now. Let's now recognize the gentlewoman from New York, Ms. Maloney.
Thank you, Mr. Chairman and Mr. Ranking Member. I would say that what this hearing shows very clearly is that the classification system is broken and it needs to be reformed. This is something we could work together on in a bipartisan way. And in fact, I will introduce this week a sense of Congress that the classification system needs to be reviewed and needs to be reformed. I have here an email that the State Department marks as sensitive but unclassified, clearly calls it unclassified at the top and at the bottom, and yet the FBI called it classified. Now, there's clearly something wrong here. Now, this memo was a memo written by a senior diplomat, a Jeffrey Feltman, and he was the Assistant Secretary for the Bureau of Near Eastern Affairs, a senior diplomat. It's his personal email, and he calls each paragraph that he wrote SBU, which stands for sensitive but unclassified. Now, if you look at the State Department's Foreign Affairs Manual, it clearly says, sensitive but unclassified information is, and I quote, not classified. So I would like to ask you, Mr. Kennedy, if you received this from a senior diplomat whose judgment you trust, and he marks unclassified at the top, at the bottom, and 4 other times in the body of the document, would you think the document is unclassified?
I think the document is unclassified, but, Congresswoman, if I received a FOIA request and the text contained foreign government information that had been shared with us in confidence, I would not wish it releasable to the world.
We heard that. We heard
that. That is the underpinning of our discussion, ma'am.
We hear that. The chairman hears it. We're going to work on it. But my point is there is something clearly wrong with the system where an individual is charged with criminal activity because they receive a document that's marked unclassified, 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 and then the FBI comes in and says, oh, it's classified. So the whole system of classification, in my opinion, needs desperately to be reformed. And I would say that every member of this panel on the Republican and Democratic side, if we receive this memo, we would think it's unclassified because that's what it's stamped. But this was part of what the FBI called classified at the time. And I see this as something that needs to be corrected and it needs to be reformed.
If I could, I fully and absolutely agree with you, and that is why we have been for years seeking the ability for a FOIA exemption that would permit us to make foreign government information exempt.
We heard what you said, but my point that I am making right now, although that's an important one, is that this system is fundamentally flawed when an individual, in this case, Secretary Clinton, received an email like this one and is accused of criminal activity for relying on the judgment of an experienced diplomat that is trusted by the State Department.
I fully agree with you.
And I feel that that is really outrageous. I would say it's an abuse of power, it's wrong, and it needs to be changed. And we are the Government Reform Committee. We should start working on it right now. It is explicitly designated in, let's see, 1, 2, 3, 4, 5, 6 places as unclassified. And now the FBI is saying that is classified. Mr. Chairman, I ask unanimous consent to place this document in the record. I think it is a strong example of a system that is broken, is not working, is hurting our government, misleading people, inappropriate, and just plain wrong. My question is, why haven't you reformed this before?
Because we have been seeking for multiple years a statutory change that would give us the same authorities that the Department of Defense and the Department of Energy have. So this would not have been classified, it would have been marked exempt from public release under a new legal.
But clearly, right now, it is marked as classified by the FBI. The State Department is marking it unclassified.
The State Department was forced to mark this classified in order to preclude public release to the entire world.
Sir, my point is, it is marked 1, 2, 3, 4, 5, 6 times as unclassified. If I was working for Secretary Clinton, I would have handed her this document and said, Madam Secretary, it is marked unclassified. See, it's unclassified, unclassified, unclassified. And now, because of this quirk, which needs to be corrected, it's now a, quote, criminal activity. There is something terribly wrong with this system, and I believe that you should have worked in the most earnest way to have changed this and stopped. I consider this an abuse.
I fully agree with you.
It is a flawed system
The
that clause- that
gentlewoman's,
claims that this is a
Gentlewoman's
criminal
time.
activity. It's wrong.
gentlewoman's time has expired.
May I finish?
Let's move on. You asked for unanimous consent. Without objection, so ordered. That will be entered into the record. Let's now recognize the gentleman from Texas, Mr. Farenthold.
Thank you very much. Ambassador Kennedy, Secretary Clinton said she had only had convenience in mind when choosing to use a personal email account. Has this been convenient for State to respond to the FBI?
I'm sorry, I don't quite understand the
Was it
question.
convenient, because of Secretary Clinton's use of a private emails account for her email, she said she used it for convenience. It may have been her convenience. Was it convenient for the State Department to comply with the FBI inquiries because she did this?
Well, we would have had to review her documents for public release under FOIA, whether or not she had used one server or another server.
So how did Secretary Clinton's emails from her private server get delivered to the State Department? Did she send you a copy of the PDF file? Did she send you or the PST files from Outlook? How did they come to the State Department?
We received approximately 55,000 pages in hard copy, sir.
So the fact that they weren't on any of your servers, they came on hard copy, so you had to scan them, I guess?
We have a system that we use for processing documents.
So
that
it would have,
uploads them.
it certainly would have been a whole lot more convenient and less expensive for the taxpayer had she been on the State Department servers. Would you agree with that?
If they had been available to us electronically, we would not have had to scan them. Yes, sir.
And the State Department uses something called SMART. Can you tell me about the State Messaging Archive and Retrieval Tool Set?
Yes, sir. SMART is a tool that we had developed. It was an early attempt to come up with a system that would make archiving and retrieval easier. It was something that was never fully adopted because it has significant flaws to it. That is one of the things that Ambassador Jacobs and a team that works for me have been working on to put into place a new system that would replace SMART because it was good, but it was not successful.
But now, because Secretary Clinton's emails were not on SMART, it ended up taking more time, being less convenient, and was more expensive. Is that not correct?
No, sir. No, sir. The Executive Secretariat did not adopt SMART and did not adopt it before Secretary Clinton's tenure. So the decision of not having her emails would not have been on SMART even if they were in our system because of the inadequacies of the SMART system. And that was not her choice. It was a previous Executive Secretariat.
All right, so let's go to Ambassador Jacobs. Y'all are talking, we've heard lots of testimony today about how much time and money responding to all these requests have taken. It seems like coming up with a system to do that efficiently would be a priority. Where are we in that? I mean, it sounds like y'all's budget have gone up, your production has gone down. I mean, it seems like we're in a lose-lose position right now.
Thank you for the question. Thank you for giving me an opportunity to talk a little bit about some of the changes that we are making that I think are going to make us much more efficient and effective. One is the whole email, the use of email is something that not just the State Department, but I think other federal agencies have struggled with as to the amount of emails and how to capture them and store them. We, the State Department, all federal agencies are under a mandate issued by the National Archives and OMB to capture and manage all of our email traffic by the end of this year, December 31st, 2016. To do that, we are, first of all, you heard earlier about the capstone approach, which was approved by NARA for capturing all of the emails.
So where are y'all, again, I'm limited time, where are y'all in implementing it? Are you going to get there, and
we are, sir.
When is this going to get better?
We are, sir. We are going to meet the December 2016 deadline, I'm happy to say. We are capturing all those emails.
Yep.
We're going to capture the emails of other people, and we're acquiring new technology that will allow us to search said email.
All right, and finally, have we learned a lesson that we're not going to let future secretaries of state or high-ranking officials use private email servers? Are we going to keep them on a government server where we can manage them?
Sir, we have taken several measures to make sure that that happens.
You agree with that, Ambassador Kennedy?
Absolutely, sir.
All right, now I'll yield back the remainder of my time.
Could I answer one other point? You're absolutely correct, sir, that we have managed to squeeze additional funds and place them in FOIA, including for some of the equipment that Ambassador Jacobs is talking about. However, as we have been increasing the budget, the demand is up over 200%. We are now receiving 30,000 FOIA we have 30,000 FOIA requests pending, and the number of people asking for material keeps going up. So that is another reason why we are very committed to getting this done.
And it's actually reassuring that number is going up. It makes me glad more people are concerned about how their government operates, and the increased transparency throughout our nation's capital and our government is a good thing.
As the gentleman yields back, I'd point out, though, that in 2008, the State Department was spending about $400,000 in lawsuits. Now they're spending about $4 million in lawsuits. So it is duplicitous to say we're trying to say, hey, we're trying to open up the openness and transparency. At the same time, you're in federal court fighting, arguing not to release information that's owned by the public.
Mr. Chairman, may
Now,
I?
we're going to recognize the gentleman from Oklahoma, Mr. Russell, now for 5 minutes.
Thank you, Mr. Chairman, and thank all four of you for being here today. We do appreciate your long service to our country. Ambassador Kennedy, do you believe that Congress has a responsibility to hold the government accountable?
Absolutely.
Okay. Do you believe that government agencies should withhold information from Congress, either classified or handled secretly in our classified vaults, or unclassified information that would be handled by our committees?
I am not in control of special.
But it's important that someone with your dedicated decades of service, ambassadorial level, you have handled a lot of classified information. So
I am always prepared to share classified information with Congress. But
we appreciate
I note
that.
that under the rules of the House and Senate, it's House and Senate rules that give the Senate Select Committee and the House Permanent Select Committee on Intelligence privileges that are not available to others, and so sure. I cannot jump over House and Senate rules, sir.
And I think we're all in violent agreement on that, but it is important that those select committees have information. If what I've read in the vaults regarding Mrs. Clinton's mishandling of classified information were known to the American people, as I've been in the vaults to peruse them, the American public would be absolutely appalled. But we can't talk about that. Instead of focusing on this mishandling and its subsequent obfuscation by Mrs. Clinton, by members of her personal staff at Department of State and by her attorneys, we are now seeing a typical play: admit nothing, deny everything, make counter-accusation. Take the case of Secretary Powell. Listening today, one would think that he was somehow doing what was just normal for secretaries of state in the State Department by not securing things or not being in a proper closed loop with State Department communication. When reality is, General Powell said, the truth is, and I'm quoting, she was using the private email server a year before I even sent her a memo. He also states in statements that he had no recollection of a dinner conversation advising her to take such actions to circumvent anything. But it does bring up some questions, so let me ask them. Ambassador Kennedy, did Secretary Powell use 12.5 devices and make nearly all of them disappear and destroy some with hammers?
I'm not aware, sir,
okay.
of Secretary Powell's, what Secretary Powell did or did not do with his private.
Did Secretary Powell or his proxies use bleaching software to eliminate any trace of federal records on separate servers after they had been requested?
I'm not aware of Secretary Powell's practice.
I'm not either. As to classified information, well, did Secretary Powell keep or provide private servers for any email communication?
I know that Secretary Powell...
Not a private email account like Yahoo or any AOL. We're talking private servers.
I do not see a difference in
Okay,
distinction
I
there,
don't
sir.
either. I think we're in the same conclusions. As to classified information, how is it that the Department of State staff, which are very able, and the FBI, which are also very able, were able to determine what top secret special access program information was, enough so to withhold it from Congress, and yet somehow we are to believe that Mrs. Clinton was somehow not intelligent enough to discern the difference between special access program information or not? How is it that the State Department, with all of their experience, and the FBI, with all of theirs, were somehow better qualified than someone who had been a United States Senator or someone who had been, say, a Secretary of State? How is that possible?
To answer that question, sir, we would have to be in another forum.
And we will, and so we'll get to ask it again. And let me ask you, in your experience, which I greatly admire, by the way, sir, administration to administration, I served decades in the military. I held a top secret, special compartmentalized classification in the military. I know how to handle sensitive information. I know you do too. Did you ever, in your career or experience, think it was appropriate to cut and paste from a classified setting, whether it was marked anything, but to cut and paste from a classified setting and to paste that information to an unclassified setting? Would that be a practice that the State Department, under any set of rules, would be appropriate?
It is not, sir, but I have seen in all the material that I reviewed no evidence, nor did the Inspector General or the FBI find that the Secretary of State, former Secretary Clinton, did so.
Well, then we will have in the classified setting maybe some further questions to ask. This is what is exasperating. Since 1814, we the people empower the government, which we draw our power from the consent of the governed, to uphold the Constitution of the United States. I've been doing it since I was 18, now in a different capacity. We have a responsibility for oversight, and we must not exasperate the American people. They can see what is clearly understood, and yet we play these delay games, admit nothing, deny everything, make counter-accusations, put hurdle after hurdle so that the clock will somehow run out. Oversight is infinitely important, and we must provide that information. And with that, Mr. Chairman, I will yield back.
May I respond, sir?
No, we got to keep the pace going here. We'll now recognize the gentleman from Alabama, Mr. Palmer.
Thank you, Mr. Chairman. Ambassador Kennedy, a FOIA requires, and this is according to the Office of Inspector, a FOIA requires a response within 20 days. But the Secretary of State's office on multiple occasions has taken more than 500 days to respond. While the average response for federal agencies across the government for a simple request is 20.5 days, the State Department's average is 91 days. For a complex request, the government-wide average was 119 days. The State Department average is 535 days. What do you believe is a reasonable amount of time to respond to these FOIA requests?
Sir, obviously we want to go faster, but there is a significant problem here. We used to get maybe 10,000 FOIA requests a year. We are now, this year, we'll have a backlog of 30,000. I have poured additional resources into it. We have gone from some 64 people to 93, and depending on the budget for FY17, I'll push it under 118.
Do you prioritize requests? For instance, when you received a request for producing a calendar, is that a simple or complex case? I mean,
no. In order to be responsive to the Freedom of Information Act as we interpret it, we use FIFO, first in, first out.
So, but
And
this
so-
wouldn't have been would this have been a Freedom of Information request for the calendars? If we request the calendars, would you,
No.
how long would it take you to produce the calendar?
There are two separate strains. There is congressional document requests and the request under the Freedom of Information Act or the Privacy Act. One are public requests, one are from the Congress. And as I responded earlier to the chairman, we will engage as soon as I get back this afternoon on the subject. We have.
How long do you think that'll take?
I know we are partially through the Associated Press request.
I just ask a request, if the chairman asks for the calendars, how long will it take to get the calendars?
I have to find out how many more have to be processed.
How many more what?
Because we at least, as a courtesy, as part of the agreement, we mark documents to the Congress about whether or not their public release would be detrimental to
This
national
is just a
security.
calendar.
If the Secretary of State was having a meeting, a sensitive meeting with a foreign government, a figure.
She's not there anymore.
That the existence of that meeting, sir, could be dispositive along the lines of activities the Secretary Kerry is carrying on. I'm not talking about, sir, to be clear, withholding information from you, but we have to process it so that you know what we consider sensitive as opposed to
Let me move to
classified.
something else. According to the Inspector General's office, the State Department has previously reported that certain records did not exist, only to later report that they actually do. Mr. Finney, it's your responsibility to ensure that the historical record is complete. Is that an accurate assessment?
Yes, sir, for the Office of the Secretary.
And I believe that you do that. You do a good job at that. I believe that you make a professional and honest effort to do that. Does it concern you that you don't have all of Secretary Clinton's records?
Sir, it always concerns me as far as making sure that we're taking care of getting the records for the archives for the State Department.
Do you think you have all of her records?
Sir, I have all that has been given to us, and that's what we're processing.
Are you aware that records have not been given to you?
Sir, all I have is what we have been given.
I'm asking, though, are you aware that there are records that have not been given to you?
No, sir, all I have is what we've been.
Are you aware that there's a missing laptop and an external storage device?
No, sir.
Well, there is, and the response that I believe that came from the Secretary's office, is this correct, Mr. Chairman? You can, if this is incorrect, you can correct me. But they said it was lost in the mail. Now, I would assume that this laptop contains information that should be in the record. It was a State Department laptop, State Department external drive. What I'd like to know is if it was lost in the mail, did anyone make any attempt to file a lost parcel claim with the post office?
Sir, I don't have any information on that at all.
Well, I'd like to find out,
If I might,
Mr. Kennedy.
If I might, Mr. Palmer, to the best of my recollection, piecing your question to my knowledge, is the laptop in question was not a State Department laptop. It was not State Department property. And therefore, we don't know what was personal information on it or not. But also in response.
But here's the reason we're here, is because she was using non-State Department software, non-State Department servers, non-State Department communications devices, many of which was destroyed. Some of the electronic documents were bleached so that they're not recoverable. And you've got a laptop and an external storage device that's missing, they claim is lost in the mail. And I'd just like to know if there was any effort made to recover it, because it fits a pattern. And I can't help but be a little bit skeptical about what's coming from the State Department and from former Secretary Clinton about their willingness to provide the information that's been requested.
If I might, sir, the FBI has been turning over additional information that they have recovered from servers, from duplicates. We are in the process now of going through that material. We are now in the process of the first disk, which we understand contained about 14,900 pages. So we are going through that. We are committed to making sure that the federal archives are whole. And we will process the 14,900, and then the FBI has given us additional disks material that they have recovered from backups, and we will do those as well, and then make the records available.
My time has expired, but the last thing I want to ask you to do is I would like for you, even though it was not a State Department laptop, not a State Department external storage device, I would like for you to do the due diligence necessary, and this, Mr. Finney, if you have a role in this as well, to try to find out what happened to that laptop and whether or not there was an effort to recover it from the post office, if in fact it was actually lost in the mail. I yield back.
Thank the gentleman. I will now recognize Mr. Carter of Georgia.
Thank you, Mr. Chairman, and thank all of you for being here today. Mr. Feeney, I want to start with you, and I just want to make sure I understand exactly your title and your role. Your title is Deputy Director for Correspondence, Records, and Staffing Division. Is that correct?
That is correct, sir.
And you have the responsibility of conducting and coordinating FOIA searches in response to FOIA requests?
That is correct for the Office of the Secretary, yes, sir.
For the Office for the Secretary of State. Mr. Finney, according to a deposition that was given by Karen Lang by Judicial Watch, your office was under the belief that then Secretary Hillary Clinton didn't use email for work-related purposes, and your office was not aware of this email use until, according to sworn testimony, 2013. Is that pretty much right?
Now the specific dates, but that's what my director said. That is correct, sir.
Okay. During Secretary Clinton's tenure as Secretary of State, did you know she was using a private email for work-related purposes?
No, sir.
You did not know that?
No, sir.
According to the State Department IG report, there were dozens of people who knew about it. They knew that Secretary Clinton was using a personal email account, and they knew that she was using a personal server for work, but you didn't know. And according to your title, it would appear to me that you should have known. Why do you think they didn't tell you?
Sir, I couldn't give you the information or the reason why, sir. I just don't have that information.
Did you ever ask if Secretary Clinton was using a personal email?
No, sir. The question I asked was when she came on board, and even after we saw the picture on the news, was does she have a state.gov account? And when they told me she did not, that's where it stopped, sir.
So what does it mean that she doesn't have a state.gov account?
When she doesn't have a state.gov account, basically you're just looking at as far as the accounts that are being able to do emails that are assigned to the actual SCSRM, which is our Information Resource Management shop, who creates those accounts.
Did that concern you, the fact that she didn't have one?
No, sir, and the reason why is because when I asked the question, and I said, and I was told that not only did she did not have a state.gov account, but our prior secretary did not have a state.gov account, as well as the previous one as well. So you're looking at Secretary Rice, Secretary Powell, and Secretary Clinton did not have a state.gov account. So when they told me that, that's when I said, okay, I understand.
Okay. It's been established that obviously Secretary Clinton was using a personal email account to conduct official business. Did you know this?
No, sir.
Did anyone else know it?
I can answer that question, sir. I don't know what I know, and I didn't know.
The fact that she was using that personal email, should you have known it? Should you have been made aware by your superiors?
Can I refer that to our director?
No.
Okay.
I want to know from you. I want to know, in your position that you accepted, did you feel like you should have known?
If she's using a state.gov account or a Gmail account?
A Gmail account.
Okay. I would say what we do today, and it's standard, is basically as we briefed the folks, as we do today, based on the Federal Records Act of 2014, if you're using your personal device, you're required by law to make sure that it's sent to your state.gov account. And that's what we would share.
So you do believe that you should have known, and you're the Deputy Director for Correspondence, Records, and Staffing Division. When FOIA requests come in, it's your responsibility. You should have known that, correct?
What I'm supposed to be knowing is making sure that I've captured all the records for the Secretary. So again, when I conduct our briefing with the agency records officer, we're making sure that we get all the records. And so that's where we stand.
So you, in order to fulfill your responsibilities, you would have had to have known. Isn't that correct? No, Ms. Lang, I'm asking Mr. Finney. Isn't that the way you understand your responsibility?
To fulfill my responsibilities, I'm responsible for making sure that I get the records for the Office of the Secretary. And so that's one of the things when we brief, we're making sure that we get those records, sir.
Okay, Mr. Finney, it's obvious to me that you take great pride in your work, and I think you're an exemplary public servant. But it's got to concern you that you weren't given all the tools to perform your responsibility. It would me if I weren't given all of my tools that I needed to perform my responsibility. Does that concern you at all? Do you feel like they were hiding something from you?
Sir, all I can say is this, is that what my job is to make sure I collect all those records. And so when I was going
But in order to do that job, you've got to know, and you didn't know because they didn't tell you, even though they did know.
Again, I can't say what other folks know. I can only tell you what I knew, and I didn't know that. So again, it's me going forth doing my job.
Okay, one last question, okay, Mr. Feeney? Do you think that they purposefully didn't tell you?
No, sir.
You don't?
No, sir.
You know, it's just bothersome to me that you and this responsibility as being Deputy Director for Correspondence Records and Staffing and having the responsibility of filling FOIA requests, yet you didn't know, how can you perform your responsibility? And yet others did know, and they knew that that was your responsibility.
Again, sir, I couldn't tell you what they knew. I only can tell you what I knew. And then when they knew about that, I couldn't speculate.
Okay, Mr. Chairman, I've run out of time. Thank you again, Mr. Kinney, for your service.
Thank the gentleman. We'll now recognize the gentleman from Wisconsin, Mr. Grothman, for 5 minutes.
Sure, a couple of questions for Mr. Kennedy there. Did you ever have a chance to talk?
Did you ever have a chance
to talk to Secretary Clinton about Freedom of Information requests regarding other things? Did this ever come up at all during your tenure?
No, sir. No, nor did it come up under Secretary Rice's tenure or when I was Executive Director of the Secretariat for Secretaries Baker and Schultz. This is handled by a special office who is led by very competent people.
Never talked about?
No, sir.
Do you ever meet Ms. Clinton?
Every morning, sir, when she was in town.
So all this time, and there was never some other Freedom of Information request that you felt was interesting enough that it should be mentioned?
Sir, I did not handle daily Freedom of Information Act requests. We have very, very professional staffs who do that. I responded. I received Freedom of Information Act requests that were brought to me about records I might have. I responded to them.
Any one of the other three of you, be it Secretary Clinton or Secretary Kerry, ever have any discussion at all with regard to Freedom of Information requests?
We certainly have had a number of them of general subjects.
Not you, I mean the other three. You said you've never talked about it.
You added Secretary Kerry, and so I was.
The other three of you?
Sir, I did have a conversation with Secretary Kerry about records preservation and FOIA processing when I was asked to do this job, and certainly can tell you that he has a great interest in looking into our procedures and practices to try to improve
Any of
them.
the other, and I'm not sure, how long were the others of you in your current office when Ms. Clinton was Secretary of State, or in the department?
I was in the department, sir, but I was not in my current position when Secretary Clinton was in office.
Do you ever have any interactions with her about Freedom of Information requests?
No, sir.
Okay. Mr. Finney?
No, sir.
Okay. In Ms. Lang's, and this is for Mr. Kennedy again, in Ms. Lang's deposition, she states the only way that State would have known if Secretary Clinton or Ms. Abadan turned over her emails responsive to the request would be their statements on the topic. Is that true? You're kind of just at the mercy of her own statements as to whether everything was turned over?
Currently, sir, there's three kinds of records in the State Department. There are what we call paper records, memorandums. There are telegraphic records, and there are email records. The telegraphic records and the paper records are maintained centrally, and that is what we are doing now, as Ambassador Jacobs has outlined, both with the Capstone program and the other new program we're going to have in place by December 31st. We will have all records all records captured.
Okay. Well, obviously you don't know if you have all records captured because a lot of these records were destroyed, correct?
I'm talking about, I thought your question was about the present time. By putting this system in, you will not, you will not be able to destroy an email record because it goes to your machine and it goes to a central repository and you cannot extract it.
There was nothing at the time, though, nothing in place to make sure that these records were maintained at the time Secretary Clinton was Secretary?
Prior to 2014 and the change of the Federal Records Act and the new NARA standards, that was not a requirement then. But we still, as I said, if I might quickly, sir, I know your time is, we have not ever talked in this hearing today about there are really two major sources of records in the State Department. The memorandum records and the telegraphic records, those are centrally archived and they are always locked in, locked down.
I think given, our concerns, our special concerns with regard to Secretary Clinton, I think the most important records are the records that show correspondence with her and people outside the building or outside the department, right? And
many of those, sir, are in our telegraphic and our paper archives. And I say paper archives, they're electronically maintained.
I mean the emails that she would have had going back and forth with people outside the building.
There is no question, sir, that we needed to improve our records maintenance. We're now up to 1 billion emails per year, and that is a huge challenge, and we are meeting it.
I'll give you one more question, and it would seem to me that some FOIA requests are more important than others. I don't mean to say that, but it's just true. And obviously, when it deals with the Secretary themselves, and particularly a Secretary who, it turns out, had such huge financial dealings that concern her and her immediate family, don't you feel that maybe in responding to these requests, you ought to make sure that requests directly affecting the Secretary should bubble to the top?
That is very hard to do, sir, when, per statute, I have to respond to every single FOIA request within 20 days. And so in order to avoid more lawsuits, we treat these things as first in and first out, and then we're at least able to assert to the courts that we are trying to move through this in a logical and measured progression.
Thank you. We're almost done. So I have just a few more questions. Mr. Ambassador Kennedy, when was the first time you knew that Secretary Clinton used a personal email address? Your microphone, please.
That came very, very late in the process, Mr. Chairman. I think it came to me probably in 2014.
The State Department Inspector General report says that in August of 2011, you discussed in an email with Cheryl Mills and others that Secretary's BlackBerry wasn't functioning, quote, possibly because her personal email server is down, end quote. That raise any red flags for you?
None whatsoever. I knew that Secretary Clinton had a personal BlackBerry. In fact, I had been asked. They had asked about personal BlackBerries, and I was told that she had a personal BlackBerry for keeping in touch with her family. So I was aware she had a personal BlackBerry.
What about a personal email server?
If I remember the exact email you're referring to, Mr. Chairman, that was in there, but the main reason I was on that was regarding a failure of her telephone system. I had been working on the telephone system, and this email came back talking about the telephone system and something about the server, and I admittedly never focused on that because I was desperately working to make sure that her classified and unclassified phone systems were restored.
You received emails from her personal account.
Sure.
You never noticed that during her entire tenure that she was in the state?
I received over a 4-year period, there were a few dozen exchanges with Secretary. That was a very, very small number, and since I had never received an email from Secretary Albright, Secretary
I'm not talking
Powell.
about anybody but Secretary
I
Clinton
understand.
at this moment.
But for context, Mr. Chairman, receiving a few emails, many of them related to things that she was asked at a cocktail party or asked on a weekend, including who can I put someone in contact for consular services. It did not strike me as abnormal to get an email from the Secretary of State in the evening or on a weekend from her personal BlackBerry.
From her personal email or personal BlackBerry?
I knew she had a BlackBerry.
I asked about your email.
The BlackBerry, that's how she sent emails.
I understand that's
on
the
her
device.
BlackBerry.
I'm talking about the email and the email address. This is a .com.
That comes on a BlackBerry, sir, too. You can get .com
No, but
on a BlackBerry.
I want to be precise here. You can have a BlackBerry that had a .gov account.
And you can have a BlackBerry that has a .com or a .org or a .edu, sir.
Yes, and so the question I'm asking you isn't about the BlackBerry, even though that was problematic. I'm asking you about you sending and receiving emails, interacting with the Secretary of State on official business. I have one here, for instance, from December 22nd, from hdr22@clintonemail.com to you and a couple others. I mean, I've got it chock full of examples where you're going back and forth on official business, her using a .com, and you never noticed that?
No, I didn't say that, Mr. Chairman, at all. I said...
You said you was first aware in 2014. She'd already left office.
When she had a personal email server.
I'm asking, there are servers, there are devices, and there's email. I'm talking about her email address.
As I said...
Don't conflate them.
As I said a minute ago, Mr. Chairman, I said that I had probably 36 exchanges with the Secretary over 48 months that were with her personal. I've admitted to that.
Her personal what?
Her personal email address, her personal BlackBerry.
And that didn't raise any flags. You never noticed that.
I admitted I noticed it, but I did not find it consequential, the small number of emails over 48 months when I never received any emails. If I had gotten hundreds and hundreds of emails from her, I would have taken
So
notice.
what's the threshold where you raise the flag? Don't you know that on official business you're not supposed to be using a .com address?
The rules in place during Secretary's tenure is that you could either print off a copy of it or you could send it to your personal storage device somewhere. And so I had no reason to know that these were not being recorded somewhere. I had no reason to know.
I think you did. I think this is one of the big errors in all this, is because nobody spoke up and said things. In fact, let me go back. There were some people that spoke up and said this. There were some people that questioned it, and they were told not to question again, and that's in the record. My time's short here. Let me ask you, Ambassador, Monica Hanley, explain to me the role that Monica Hanley's role played with Secretary Clinton.
Monica Hanley was part of this sort of a cross between scheduling and advance, worked on the Secretary's travel and moved with her when she went to events outside the building.
She was a personal assistant to the Secretary.
A variety of responsibilities.
Does she still work at the State Department?
No, sir, she does not.
Do you recall when she left the State Department?
When Secretary Clinton left, she was a non-career employee.
And let me ask you, switching gears here, is it legal or illegal to share classified information with somebody who does not have a security clearance?
It is inappropriate. I believe it may be illegal as well. I am not a lawyer.
Would it concern you that if somebody had access to classified information who did not have a proper security clearance?
Yes.
Did Monica Hanley lose her security clearance when she left the employment of the State Department?
Yes.
Is that the regular routine? When people leave the employment of the State Department, they should lose their security clearances?
They don't, if I could say, sir, the security clearances are not lost.
They don't have them anymore?
They no longer have one.
Fair enough.
A loss is an
Yes.
administrative action.
Agreed.
Termination of your employment terminates your access to classified information, with some exceptions.
Do you recall what level of clearance Monica Henley had while she was at the State Department?
Been top secret, sir.
Could you provide to this committee the time that she had the security clearance and when her security clearance was taken away? Is that fair?
Her security clearance was never taken away. It ended with her employment.
Sorry, security, and the time that her security clearance ended.
We can provide.
I'd just like to know what level of security clearance that she had along the way. Did the State Department have any official relationship with the Clinton Foundation?
Official? I don't believe it. I would have to check, and I don't think it had an official relationship. We don't usually have official relationships with foundations. We deal extensively with huge numbers of charitable foundations, though, extensively.
There is no relationship, in your understanding, between the Clinton Foundation and the State Department to provide services or products or personnel for the Secretary to do her official business while at the State Department?
I am not aware of any.
Okay. Let me now yield or recognize the Ranking Member, Mr. Cummings.
What would be the, just following up on the Chairman's question, you said that there are exceptions when a person is no longer employed at State, that they would maintain, I guess, what kind of exceptions are there?
There is a presidential executive order that permits former presidential appointees to retain a security clearance for the purposes of reviewing materials that they saw, generated, or handled only during their tenure. So I was trying to be very precise.
Yeah, well, thank you.
In response to the Chairman's question.
You know, one of the things that is interesting about all of this is that there seems to be a belief by many on this committee that there has been intentional stalling, if not obstruction, with regard to providing documents. Can you talk about that, Mr. Kennedy? Because I just, I listened to you carefully, and you talk about, I'm not accusing you of that, but you talk about all the documents, all the emails you have to deal with. You ratcheted up your budget, transferred money so that you could deal with more. You talked about the priorities. You talked about the FOIA 20-day rule. Talk about that, too, because I don't want the American people, I want you to have an opportunity to say how you feel about your office, your employees, and what you're trying to do. I don't want that just hanging out there.
Certainly. Thank you very much, sir. Look, we take our FOIA responsibilities very seriously. We were very, very pleased in 2013, for example, where we managed to close more cases than we received. When in 2014, then we almost did the same thing. We got in 20,000 cases and closed 18,000. In 2015, though, the curve just started to take off. We got 24,837 requests, which was up 5,000 from the year before, up 6,000 from the year before that, up 10,000 from 3 years before that. The volume of FOIA requests that are receiving are growing exponentially. We have put additional resources into it, but it keeps growing. The State Department's operating budget during that same period, and we get great support from the committees of appropriations, but they operate under caps. So the State Department's operating budget is down 25% in constant dollar terms from 5 years ago. The workload is up maybe 300%. And so we keep putting resources into it, but I cannot yet find a way to keep up. That's why I have teams working with Ambassador Jacobs, new technologies, more personnel. We have an obligation under the law, and I believe to the American people, as I believe was Mr. Russell talked about. We believe that this is our responsibility. We are carrying it out to the maximum extent possible. But with these many documents under request, and then one last thing, if I might say, Mr. Ranking Member, is that a request to a government agency that does not handle classified information, does not operate in 275 locations around the world with multiple bureaus and responsibilities, that's an easy push. I believe it was Mr. Garthman's question about, I'm sorry, it was Mr. Palmer's question about timing. They can churn those out very quickly. We get very, very complex national security document requests. And those materials contain our material, references to other agencies. We have to coordinate with the intelligence community, with the Defense Department, potentially the Department of Energy, the Department of Justice, the Department of Homeland Security. It simply takes a long time to do those. And then we breach the 20-day rule. And then we get sued, which, as the chairman points out, causes us even more business expense. I will never, I don't think, and I hate to admit that because I don't like to admit failure, think we'll be able to admit that we're going to be able to turn out complex documents.
It's not because you don't want to, or you're trying to obstruct, or...
No, sir, absolutely not. We have put more and more people, as I mentioned. We were working with 64 people, pushed it to 81, then to 93, and depending on the budget for FY17, we'll push it up to 118. And we're deploying new technologies and additional better training for our personnel. When we can automate this process better, especially on the emails, as I mentioned to the chairman a few minutes ago, our telegraphic records and our memorandum records are much more easily searchable because they're in a searchable format.
I'm almost finished.
Emails need a lot of work, and that is what Ambassador Jacobs is directing.
You know what? I was sitting here listening to you. I was trying to figure out what makes you guys happy. In other words, when do you say, boy, we really did a great thing, let's go out and have a beer and celebrate? Because it doesn't sound like sexy work, by the way.
Well, I take incredible pride in the competence and the dedication. In order to get those 53,000 pages of Secretary Clinton's records out, we had people working, 10, 12 hours a day, 7 days a week, impinging on holidays. We have an obligation to the American people. We will do everything we can to meet it. But there are certain structural, mechanical, software limitations that we're facing. There's also the colloquy that I had with Congresswoman Norton about our requirement to protect foreign government information. But yet I don't have the exemption that the Department of Defense or the Department of Energy has. That means we have to classify every one of those documents. That is a specific and time-consuming action. Yet if you just marked it with the correct B designation for foreign government information, I think that would take a huge burden off the State Department in terms of responding to routine requests, because we have to deal with them as they come in. But it would also take away the misimpression that, oh my God, there were 2,000 emails that were classified as confidential, and it's really about somewhere between 60, 70% of them were classified confidential only because that was the only way that I have under current statute to protect foreign government information, unlike the Departments of Energy.
Let me just close. First of all, thank you for your response. And although I said it jokingly about sexy work, I said it to emphasize that we're grateful for what you all do. I know sometimes you think it's thankless, and you hear a lot of complaints, but we do appreciate it.
No, it's an honor, sir, to serve.
Mr. Chairman, I just wanted to close by pointing out that we've heard today about a broken and a flawed classification system. And I think if we don't do anything else, if we can try to help with this system of classification, because it is so serious and can create all kinds of problems, And I'm looking forward to working with you in an effort to try to address these issues as best we can. And with that, I want to thank you all.
I thank the ranking member. I do think we need to work collaboratively on not only the classification process, but also the security clearances, because my goodness, you got millions of people with security clearances. And I still hearken back to what Senator Patrick Moynihan spearheaded some 20, 25 years ago. I can't remember the date, but when he basically issued a report, good bipartisan report, that said, when everything's classified, nothing's classified. When everybody has a security clearance, nobody has a security clearance. So I do think that that's a long-term project that I would love this, this committee to engage in. I need to ask one last thing because it does impact the four of you that are sitting here. You have this trove. It's by the tens of thousands. You look at these federal records that are now suddenly dumped on your lap that didn't know were there. And then you also look at all the requests, congressional requests, subpoenas, FOIA requests, media requests, sometimes come in as FOIA, sometimes don't. How do you take those four sets of requests and cross-reference it with probably information from Secretary Clinton's federal records that should have been included? Is the idea that you're just going to throw them all up in the internet and everybody's going to have to go hunt and peck through the 55,000? Or are you going to go back to a subpoena and say, all right, that was actually not as responsive as it probably could have been. This FOIA request was incomplete because it should have included this particular email or her calendar or whatever it might be. How do you take this set of the 55,000, or the pages, and now we hear it's tens of thousands more than that. How do you do that and cross-reference it with the thousands of requests that had been peppered into the State Department over the last, since 2009?
I think there are two ways to do that, Mr. Chairman. We could go back and go through every single previous FOIA request, and that, I think, would grind to a halt the requests and the efforts we're making now. I believe the right solution is what we are doing. We are putting all of the emails up on our searchable website. So if you ask about Xanadu and we told you we didn't have any records, you could go to a special portion of our website, which has all the 53,000 Clinton records, and you could put in Xanadu, and it would find Xanadu for you.
You're not talking about the record album that from back in the 70s, are you? I'm just teasing. Keep going. Yes.
Xanadu is my favorite country.
Okay.
Because it's not a country, and I can use it as an example without ever
I thought you were a big music fan of a particular artist from the 70s.
I can
but
shift
it's okay.
to
Keep going.
Shangri-La.
Yeah.
I think that is the way for us to best be good stewards of the taxpayers' dollars, but also be most and quickest responders to the American people.
So why not just do that all the time? Forget about FOIA. Forget about subpoenas. We get stuff, well, let's put it on the internet. Good luck.
Because there is Foreign Government information, Privacy Act information, National Security Act information in that material. And
so you have no plans to go back and redo, what about subpoenas?
If we respond to subpoenas. We work very, very
No,
closely.
but if you responded to a subpoena, say, and I don't have an exact one in case, and it came across in 2011, and you just got the record here in 2016, are you going to go back and look at that subpoena?
We would, for subpoenas, which we would consult with the Department of Justice about what we needed to do to be in compliance with the court.
I think I can
Or the Congress.
Okay, so that's what I'm saying. There's this universe of sort of four areas, four buckets, and I hope I'm not missing one, but you have FOIA requests, you have subpoenas, you have congressional inquiries, and you finally have media requests, which come in a variety of different formats. So I would appreciate, what is your game plan to deal with this? You didn't ask for this, but this is what the consequence of Hillary Clinton's convenience was, is you have to deal with it. So what are you going to do? How are you going to prioritize it? And what's the expectation if somebody has a subpoena, if a company or an individual or an attorney or whatever it is, there's a subpoena out there, will you be going back and cross-referencing that
Let me
for
take,
each of those four, and I'm not expecting you to do it off the cuff. I would just appreciate if the State Department would say, this is how we're going to deal with it. And if it's not those 4 buckets, tell me what it is, but at least off the top of my head, that's what it is. All I'm asking for here is a game plan to deal with that. I don't think it's good enough to just say, we're throwing everything up on the internet and everybody good luck.
that was in response, Mr.
And
Chairman,
the
to your
FOIAs
fo-
is
to your
so,
FOIA question.
yes.
We will review congressional document requests as we continually review them. As you know, Mr. Chairman, we've sent you 186,000 pages, and if it has to be 187,000 or 197,000, we'll work with you as we talked about when I met in your office. For subpoenas, we will talk with the Department of Justice to see what steps we may have to take and have our lawyers work on that. For the media, I leave the media to take care of themselves.
They'll be so glad to hear that. But if there was a media request,
The media request would be a FOIA request, and therefore we've made it very clear to the
at
media.
least for those 4, just what's a reasonable time that you're going to get the committee, and a game plan on how you're going to deal with this?
It will, given that the legal question about subpoenas is a complex one, I think it'll have to be a couple of weeks because we have to.
End of the month, is that fair? Today's the 8th?
I can certainly try, but I have to talk to my legal advisor and I have to talk to the Department
We're going to
of
start
Justice.
waving the red flag saying, hey, you're not being responsive if I don't hear from you by the end of the month. Fair enough?
When I have to go outside the State Department, I make no guarantees, Mr. Chairman.
What do you mean outside the State Department?
I have to talk to the Department of Justice. That's outside the State Department.
Okay.
They're not under my control.
I just need a good faith effort because I think you have thousands of people waiting and wondering how this affects these 4 categories from subpoenas, congressional members of Congress, all that. That's all I'm asking.
On FOIA,
I think you get it, okay? I just need a responsive and I need a game plan and I understand the need to interact with the Department of Justice. Appreciate the work that you and so many people do at the State Department. We appreciate your attendance here today, and the committee stands adjourned.